This I have to defer till tomorrow. Tomorrow I will at 10:30.
At least if you would have known that what is the result, Lordship.
No result, I don't know now. You have to wait till tomorrow. Till tomorrow.
Lordship. Lordship, I beg to mention item 53, Lordship. This matter, yesterday this matter was listed. So may I pray, Lordship, this matter may be taken up today at 2, Lordship.
No.
Or Lordship, before Lordship rises. Little urgency in the matter.
It will reach.
Before Lordship
Okay.
rises. Before Lordship rises.
Lordship, this regular bail petition, my co-accused bail has granted by this honorable court. So let it be on Friday. I filed on 1/9.
When have you filed?
On 1/9.
Okay.
Like.
May I please, your Lordship? Permission for listing the bail matter for bail hearing, Lordship. Earlier occasion case has been listed on 26/8/2025. Due to Lordship will not sit court number 14, matter has been deferred, Lordship. Matter is very urgent, Lordship. Please the matter on Friday, Lordship. Case is available, Lordship.
8th, Monday,
Monday I am not available, Lordship.
Tuesday,
I will go to the Itanagar bench, Lordship.
Tuesday.
Lordship, on Friday, Lordship.
Okay, on Friday.
I will do.
Prayer for listing of a bail application matter, my lord, earlier rejected by this honorable court.
When have you filed?
My lord, last Thursday,
Monday.
my lord, Friday, my lord. It has not been registered till please Friday.
You have filed it on Monday?
No, my lord, last Thursday I filed. May
Oh,
kindly-
okay, Friday.
I'm deeply obliged.
Wait, please, Lordship. So listing of 1AB, Lordship, hearing matter, Lordship. Lordship, this matter, Lordship, 18/8, when it was fixed, Lordship, but not listed. Friday, Lordship.
Okay, on Friday.
May it please, your Lordship. Okay, I'm paying for listing of 2 premier revision petitions. Can it be listed on this Friday? Revision petition.
Senior bench has. Court number, senior court is there.
Therefore, this is my lord.
Yes. You have to mention before
Obliged, Lordship.
court number 14.
May I please, Lordship? Lordship, I beg to mention an anticipating bail for listing tomorrow. Lordship, the accused is a 19-year-old boy and the FIR has been lodged in Karnataka.
When have you filed?
Today,
Then you have to wait till day after tomorrow.
Lordship,
If it does not get listed, only then you mention.
Lordship.
May it please, your Lordship. Okay, I'm paying for listing of an on IA, my lord, in a BA, my lord, for correction of cost title, my lord. Tomorrow, day after tomorrow, if possible.
Okay.
My please, Lordship. The second bail application, Lordship. I am behind the bar for Lordship 68 days. Lordship, FIR is on page 13. Is
What is the offense?
offense is Lordship under sections Lordship 61 to 147/3082 of BNS and read section 1013 of.
Case diary would be required.
Lordship, may I submit, Lordship?
No.
Out of Lordship, 10 co-accused persons have already been enlarged by this honorable court. Can you see the allegation? Lordship, page 13 is a
No,
type-
once your prayer was rejected earlier
Yes, Lordship.
after perusal of the case diary.
That's it.
Therefore, perusal of the case diary is necessary.
On that day, I was not well equipped. Today, that 8 bail orders for co-accused, Lordship. When they have completed 55
Heard
days.
Mr. P.K. Sir. We are fixing a short date.
Lordship.
Heard Mr. P.K. Saurya, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary.
10th,
Givesh, day,
Lordship.
10th of September.
Deeply obliged.
Item 3.
May I please, your lordship, charge sheeted matter, FIR is at page number 13, relevant portion page number 16. Section 29, 21B and 29 NDPS. 101 gram, 101.43 grams of heroin has been seized. The main accused is the husband who is absconding. I am the wife and I am behind the bar since 100 days.
100 days.
Yes, today is the 100 days.
At what stage? Charge sheet has been laid.
Charge sheet, yes.
What is the stage of in
Appeal-
trial? Appealing stage.
Yes, charge sheeted on 26/6/25.
Why the trial court rejected your prayer?
Rejection is at page number 5, your lordship 34. The relevant portion is page number 35. Last second, third. Last part, having regard to the gravity and seriousness of the offense and in wider implications of public health and societal welfare, this court is not inclined to grant bail to the accused at this stage.
What is your
That's
submission?
Your lordship, I am not the main prime accused. The prime accused is my
But charge sheet
husband.
against both, my lord. In the
Charge sheeted against me also.
charge sheet has been submitted against the accused person, namely Fatima
Fatima
Begum
Begum.
and her husband Habibur Rahman, 21B and 29.
Charges have been framed.
Yes, your lordship, against me also. But the prime accused, my husband is absconding, your lordship.
Yes, Mr. Parash.
Otherwise, intermediate, but now, my lord, the husband absconding. That's.
At what charges have been framed or not?
Yes, that is not aware. I'm not aware at this stage.
You have to be aware about that.
Since June, perhaps, my lord, charges have been framed, my lord.
Or it is in appearance stage only. You have to inform this court.
7/8/25 as appearance or oblique production.
Tomorrow is the date, your lordship.
Find out. We'll
Yes.
take it up after some time.
Just-
Your lordship may kindly pass over the matter for the time being. Messenger is on her way.
Okay. Or what is the stage? Investigation stage or no, whether charge sheet has been laid in this case? And what is the ground?
Okay, Ria, I'm confused, Lordship, because he is involved in two cases and both of the matters are listed today, Lordship.
Or 20,
Oh, that's how it is. Mm, 23.
prolonged incarceration. At what stage the trial is pending? We'll call for the scanned copy of the trial court records. What is your name?
Rahman on behalf of SK Nargis.
Heard Miss F. Rahman, Learned Counsel, appearing on behalf of Miss S.K. Nargis, Learned Counsel for the petitioner. Also heard Miss M. Deka, Learned Counsel for NCB. Let the scanned copy of the trial court record be called for. Registry to issue requisition for the scanned copies. Let this case be listed on 24th of September.
By please, Lordship. Lordship, I am behalf of the Mr. Ardev Lordship. He was unable to attend to the Lordship due to personal issue. With the 482 bail 83 bail application Lordship, petitioner was arrested 31st July 2025 Lordship. So this is section 21B Lordship, the commercial quantity. But Lordship, my name is.
How much contraband?
Commercial Lordship. But Lordship, thing is that my name is not in the FIR Lordship. I was arrested just because
is
of Lordship.
Pending investigation.
Pending investigation, CD.
We call for the case diary. Heard Miss. What's
Are wrong.
R. Wrong May. learned counsel for the learned counsel appearing on behalf of Mr. R. Dev, learned counsel for the petitioner. Also heard Mr. K. K. Parashar. Let the case diary be called for.
17.
Let this case be listed on 17th of September.
Item 6. May it please your lordship. The 483 bail application, lordship, and the charges are lordship. BNS lordship.
Case diary would be required.
Yes, case diary is required.
Heard Mr.
And lordship.
N. Ray, learned counsel for the petitioner. Also heard Mr. K. K. Parashar. Call for the case diary. Let this matter be listed on 19th of September.
Short date may be given, lordship.
UAP
It is the available shortest date. 19th September.
7.
Same accused,
Can we go-
charge sheeted case. Same order as in item number 4. Item number 4 of Jito order, same order, same day.
At your place.
Item 8. May I please? FIR is on page number 13, 1-3.
Boxo is there.
Yes, but let me read the FIR.
No, what is your, it is pending investigation.
Yes.
Notice shall have to
No,
go.
charges has been
Charge,
framed.
charges from,
Pending trial.
Yes, charges has been framed. My
And-
punishment period is 3 years, and I am behind the bar for 91 days.
Why the trial court rejected your prayer?
Yes, no specific ground has been. written.
Where is the rejection order?
The page number 25. Page number 25,
relevant to
order relating to framing of charges. And also bail was rejected on that very date.
victim statement yet to be recorded, page 26, last paragraph. Perusal of the case record shows that the charge has been framed against the accused today and the evidence of and material witness, that is the
Let the
victim.
victim be examined.
Yes, sir.
Then
Victim
you,
has been already examined,
victim has been examined.
already examined.
Where is the statement?
During this particular period, filing of this particular case, they have been
And
examined.
then that may be called for, otherwise that is not before us, Malad.
Let us verify.
Just one, your lordship may go through the FIR only, page number 13.
No, not now,
Notice has to be go, and in the meantime, the
not,
scan copy of the statement of the victim may be called for.
yes. Heard Mr.
Are
Eh.
they?
R. Day, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the prayer for bail of the petitioner was rejected by the trial court, mainly on the ground that the victim has yet to be, was not examined at that point of time. Stop. However, he submits that now the victim has already been examined and therefore he is praying for his bail. Stop. Let a status report be of the trial of special POXO case number 72/2025 be called for from the trial court. And if the victim has been examined, the copy of the deposition of the victim girl be also called for. That also the notice be issued to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice within 3 days from the date of this order, returnable on 19th of September, placed accordingly.
Item 9.
May I please your lordship, pass over the matter for time being?
What
Because
is the matter?
my senior is in Lakes on 25.
What is your name?
Zakir Sen.
Foxo is there, my lord.
We are issuing notice. Heard Mr. Z Hussain, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Let the case diary be called for.
Yeah, my lord, case there is long
It is
pending
not charge sheeted.
Karimganj case number 23, 2023. Earlier final report was there. Subsequently, maybe for further investigation.
Whether charge sheet has been,
Once final report was there, my lord, they have annexed 2. But subsequently, maybe further investigation order is there.
FR was submitted.
Yes.
Where?
Consider effect.
Mm,
Yes, yes, my lord, page 45 is the my lord order, whereby objection was the my lord victim information. I have objection towards the. No, this is bail petition. Annexure 2, my lord, page number 22 to 27.
Let his senior come.
My lord, yes.
We'll take it up after some time.
Lordship matter may be passed over for time being.
Why?
Lordship, my senior will appear. Mr. HRS.
Okay.
Item 11.
Well, what is the district case of a pure accident, matter? This is unintentional matter. This is not intentional, this is unintentional matter. Section 27 also it is also there, matter. But there is a matter, party matter in unintentional matter, he pulled the trigger. And matter injured one
27.
of his matter, colleagues matter. The FIR itself is fixed.
And somebody has been killed or
No,
injured,
not killed,
injured.
suffer injuries. And
Yes.
he himself matter took that person to matter AMCS, matter, and after matter some.
We'll
stable
call for
conditions.
the case diary. Heard Mr. A. Konikor, learned counsel for the petitioner. Also heard Mr. K. Parashar. Call for the case diary. Let this matter. 16-9.
Deep level.
May I please, your lordship, item number 12 and 13 for time being. Lord. My senior is engaged in foot number 14. After 10 minutes.
No, then you have to wait after lunch.
After 10 minutes.
Item 14.
14 episode Mati. Yes.
And this commercial quantity lordship.
Heard Miss J. Singh for learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. Pending investigation, charge sheeted matter. Let the scanned copy of the trial court records be called for from the trial court. List this matter on 23rd of September. Same. Charge sheeted matter.
Our name is not reflected.
Wrongly reflected as PP Assam
PP
should be
Assam.
one of SC and CB.
Same order likhibo. Registry is directed to reflect the name of standing counsel NCB in the cause list in place of PP Assam henceforth. List accordingly. Same order. 17, 23rd September.
I give that.
16.
May I please,
Yes.
Lordship, I filed a bail petition, the 483 of BNSS. Lordship, already 17 days completed, he's been in the bar. And without charge sheet.
And your lordship, the allegation is Dokaiti, robbery, assault to women, mischief,
Case
and
diary.
arms act.
Heard
By
Mr.
clause 1 clause A.
J. Abbasi, learned counsel for the petitioner. Also heard Mr.
Lordship,
K. K.
my request for
Parashar.
a short date.
Call for the case diary. 18.
17.
Maybe your lordship. Lordship, PD may be called for. Poxo is there. Lordship.
Heard Mr.
PT money.
T. Moni, learned counsel for the petitioner. Call for the case diary and issue notice to respondent number 2 in pursuant to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on 22nd September.
May please, your lordship. My lord, charge-sheeted matter, my lord, charge-sheeted under Cattle Act, my lord. My lord,
Cattle Act,
Cattle Act. My lord, I seek a similar order, my lord. He will appear, my lord.
Observation.
heard Mr. S. Das, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely, what is the name?
Jahangir Alam, my lord.
Jahangir Alam, who is apprehending his arrest in connection with Dhubri PS case number 314/2022 under section 379/411 of Indian Penal Code, read with section 13 of the Assam Cattle Preservation Act 2021, corresponding to PRC case number 62/2024. Learned counsel for the petitioner has submitted that in the aforesaid case, charge sheet has already been laid. However, the petitioner apprehends that as the offense is under, as one of the offense under
13,
which charge sheet has been laid is under section 13 within bracket 1 of the Assam Cattle Preservation Act 2021, which is exclusively tribal by the Court of Sessions. Hence, the Court of Learned Chief Judicial Magistrate may not grant bail to the petitioner in the light of the observations made by the Apex Court in the case of Prahlad Singh Bhatti versus NCT, Delhi, and another reported in 2021 4 SCC 280, wherein the Apex Court has observed that even though there is no legal bar for the magistrate to consider an application for grant of bail to a person who is arrested for an offense exclusively tribal by Court of Session, yet it would be proper and appropriate that in such case, magistrate directs the accused person to approach the Court of Session for the purpose of getting relief of bail. And then Court Para 5 of the bail application number AB 1441/2025. It is in the case record. I have flagged it. Court Para 6. Court para 7. The case is pending before the which court?
SDGM, my lord, Dhubri.
Instead of Chief Judicial Magistrate, Sub-Divisional Judicial Magistrate. Court para 7. Court para 8. CGM Nagaur Jagat, SDGM Dhubri लिखिए. When is the date fixed next?
9/10.
9/10. You appear before the court para 9. 8 and 9. Appear before the SDGM court and pray before state court. This bail application is accordingly disposed of.
Highly open.
Wait, please just wait. My lord, the FIR is at page 12. May I read the FIR? Lordship has got it, ma'am.
Page 12,
Page 12, my lord.
yes.
May I read? Subject FIR regarding illegal storage of suspected crude oil in a concealed underground chamber in a godown premise, and a blast occurred in a tanker causing serious injuries to 2 workers. I, SI so-and-so, presently posted at Joysagar OP. Respectfully submit the following for your kind information and necessary legal action. That on 9/8/2025, at approximately 6:30 PM, I received via telephonic information that one dumper blast while welding the vehicle in a godown belonging to owner Jalil Ahmed and 2 of the workers, namely Mujakir Ali and Abdul Jalil, was sustained serious injuries and were now admitted at Brahmaputra Hospital, Dibrugarh. During the inquiry, I found the modified dumper, which was converted into a tanker where the blast took place, with tin sheets and large quantity of suspected crude oil was found to have been illegally stored in a godown situated at Singhadwar Sariali, alleged to be jointly owned by Jalil Ahmed and Abul Ahmed, without any valid license or authorization from the competent authority. It has been further learned that the crude oil is concealed in a separately constructed underground chamber, which is covered with reinforced concrete flooring to prevent detection. This hidden storage arrangement indicates an attempt to evade inspection and regulatory oversight. Crude oil being a highly inflammable and hazardous substance, such unauthorized storage poses a serious risk to public safety, nearby residents and commercial properties, and the environment. It is also contravention of Section 3 and 4 of Petroleum Act 1934, read with Rule 4 of the Petroleum Rules. Well, on the basis of this, an FIR was registered under Section 61(2), 305E, 287, 288, 125B of BNS, read with Section 23. My lord, next page, Lordship will kindly see the seizure list. Although allegation is the large number of crude oil, only 500 ml of suspected crude oil has been seized. And secondly, if your lordship turns to the page number 615 is the type copy. My lord, the land where the incident took place belongs to Chiraz Ali, as per Jamabandi, my lord. He is the father of the petitioner number 1. And if your lordship turns to page 18, in the year 2023, Chiraz Ali entered into an agreement for rent with one Sanjay Sharma, and the premises was leased out to him. Lordship has got it, my lord.
Yes.
Page 18. May I read, my lord?
Now what do you want to say?
My lord, this father of the petitioner number 1 is the owner of the premises, and that premises was leased out to one Sanjay Sharma. That is not a residential premises, my lord. And if petitioners, they are no way connected. He is the son of Chiraz Ali. If any offense has been committed,
What is your name? Jalil.
I am not Jalil, my lord. I am Abul. In the FIR, it is written as Abul Ahmed, but my name is Abul Ali. And the petitioner number 2 is a labor under the petitioner number 1.
And on the date of incident, on the instruction, he went to the place for inspection. But that original, this agreement is
No,
also in my custody, my
the
lord.
godown belongs to Jalil Ahmed.
No, it is wrongly written, my lord. It belongs to my father, Shiraz Ali. Shiraz Ali, that is the Jamabandi, my lord.
Where is your name in the affair?
That my name has been wrongly written as Jalil is my brother and Abul Ahmed. I am Abul Ali, alias Abul Ahmed, my lord.
Where is your name?
My lord, the second paragraph, my lord.
Jalil Ahmed.
Owned by Jalil Ahmed and Abul Ahmed. Lordship has got it, my. The last part.
Second paragraph,
Last line, my lord.
Oh, yes.
Jalil is my brother.
Maybe Jamabandi in the name of father, but that Godam may be run by him, Malab.
But he has already leased out.
It can be reviewed from the city only.
That this original agreement is also with my custody. I'll produce it before the investigating authority, my lord. I'll corporate it. I'll produce this agreement on all documents. That lease agreement was executed in the year 2023, my lord. It is subsisting till 31st of December 2025, my lord. 31st December 2026. Page 19, my lord.
Yes, Miss.
My lord, regarding the petroleum act, though the penal provisions are not very strict, but unauthorized storage of petroleum now found 500 ml. But after the blast may occur because of that petrol storage. During the yes, two persons sustained serious injuries, and during welding, my lord, in case of welding, a little
but-
amount of petroleum product, my lord,
But
it got
his
blast. my lord.
plea is that it has been leased out. That can be verified from the,
My lord,
not Jamabandi, not Jamabandi. The lease
agreement.
agreement. Heard,
T.
Miss-
Chakraborty.
Mr.
T. Chakraborty, my lord.
P. Chakravarti,
D.
Lanet- D. Chakravarti. T.
T.
Lanet- Mr. T. Chakravarti, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Abul Ali alias Abul Ahmed and Rubul Ali, who are apprehending their arrest in connection with Sibsagar PS case number 119/2025 under section 61 within bracket 2/305 within bracket E/287/288/125 within bracket B small b of BNS read with section 23 of the Petroleum Act 1934. The gist of accusation in this case is that on 11/8/2025, one Atul Das, SI of police, had lodged an FIR before the officer in charge of Sibsagar police station, inter alia, alleging that on 9/8/2025, approximately at 6:30 PM, the informant received a telephonic information regarding one dumper blast while the said vehicle was being welded in the godown belonging to one Jalil Ahmed. It is alleged in the affair that two workers, namely Muzakkir Ali and Abdul Jalil, sustained serious injuries in the blast. And during inquiry, it was found that suspected crude oil was illegally stored in the godown constructed underground with underground chamber in order to prevent its detection. Learned counsel for the petitioner submits that though the petitioner name has been shown as joint owner of the said godown. However, the land in question belongs to the father of the petitioner, Muhammad Siraj Ali, who had leased out the said land to one Sanjay Sharma on 27th day of August 2023, and the said land is in possession of said Sanjay Sharma. Learned counsel for the petitioner submits that the lease deed is still subsisting as its validity is till 31st December 2026. He submits that the petitioner's name has been wrongly implicated in the FIR and he is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Call for the case diary. Let this matter be listed on 24th of September. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner, more specifically that the land in question has been leased out to one Sanjay Sharma, and it is he who is presently in possession of the said land, the petitioners are directed to appear before the investigating officer of Sipsagar Police Station, case number 119/2025, within a period of 7 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, they shall be allowed to go on bail of ₹30,000 each with conditions.
And deeply obliged.
24th, list accordingly.
And deeply obliged.
Well, the petitioner here before your lordship, is the victim, not the accused. Kindly have a look at page 13 is the FIR. Page 13 is the FIR. Married, no?
Yes.
Page 13. With due respect, I have the honor to report that on 20 August 2025 at about 10:35 PM, I received a phone call from the number so-and-so. The caller stated that, "Sir, we are in danger. Please help us." I instructed him to come to the police station. Subsequently, 4 individuals arrived at the police station in a Fortuner car and reported that one of them, Sri Ganeshal Karawat, was sustained a gunshot wound. Upon interrogation, it was revealed that Ganeshal Kamwat, Deepjyoti Fukan, and Chiranjit Das have been partying together near the Nova Hotel, which falls under the jurisdiction of Silapota Police Station under Dhemaji district. Then Sri Biswajit Soikia, who took his Fortuner car and approached them who were having the party. While they were enjoying the gathering, Mr. Biswajit Soikia was taking photo shoot with his pistol and Fortuner car when he unintentionally pulled the trigger by accident, resulting in a bullet being fired from the pistol and striking Mr. Ganeshal Kamwat in the waist and went through hand and through his lower abdomen and resulting in also injuring Mr. Chiranjit Das. This is the Chiranjit Das before petitioner. In his right hand, little finger. The injured Mr. Ganeshal Kamwat was promptly transported to Dibrugarh for medical treatment. Upon learning the incident, the police escorted both injured persons to Dibrugarh Medical College Hospital for further care. The incident was reported to the IC, CD, SP, Huang, who immediately proceeded to the police station. Thereafter instructed SIP Dipjuti Pegu to seize the said pistol, and accordingly, he seized the pistol in presence of the witnesses and using cotton trace for any gunshot residue was collected from the from.
No, why are you seeking bail?
Yes,
You-
Malad, where is
you
the
are-
evidence?
Now, Malad,
You are,
police-
you
now,
are the
Malad, police
victim
has- Now, police has, Malad, visit my place, Malad. Visit my
Hmm.
residence, Malad.
because you are injured.
No,
You
because
are
I-
one of the main witness.
He-
Well-
this will be taken, Malad, where
There is
the-
no apprehension.
Police has, Malad, police has, Malad, visit my place.
Police
Malad.
has to visit
And
unless,
instruct my wife to Malad appear before the police station. But that is the only appearance, Malad. Otherwise, I have appeared, Malad, before I appeared in fact, Malad.
Wife's statement may be taken because
No, I have no statement, category statement, Malad.
no, there is no, you are not an accused in this case.
Not like this, Malad.
accidentally.
But police has visited my place, Malad. 4 or 5 days occasions, Malad, police has visited.
No, police may visit for the purpose
But
of
that,
investigation.
only that, Malad, that type of appearances. Malad.
There is no apprehension. Heard Mr. A.
No, but
Koni.
I will cooperate, Malad. Only my appearances should be, Malad, taken care
No,
of.
your apprehension does not have any basis. The FIR indicates that you are victim.
But I am the colleague of the Madam Biswajit Saikia. That is the only appearance, Madam. Biswajit Saikia is my colleague, Madam. And he signed a report of police. He
Whether
was
Biswajit
before the, I don't know 11, or I don't know 11, he was before the also, Madam.
If the pistol belongs to Vishwajit Saikia, Malad,
That pistol is seized, Madam.
then Malad, if
My only appearance is, Madam, I am the colleague of the Biswajit Saikia, Madam.
if pistol
I may be
belongs to
arrested,
him,
Madam.
Malad, if pistol belongs to him, then apprehension may be there, Malad. If pistol belongs to Vishwajit
I am the
Saikia,
colleague of the Biswajit Saikia. That is the only appearance.
Now, where is the apprehension? Where is the statement?
On the page, Madam, 6, Madam.
Para 6.
Para 6, Madam.
Police visiting, how can be harassed,
Police
Malad?
visiting is not an harassment.
Madam, I
Unless,
have the appearances, Madam.
no, this is
The appearance is.
mere visitation by police is
Madam,
not.
not 1 day, but 4 or 5 days, Madam, police has visited. Madam.
They may have
In
to
the,
visit
in the night, Madam, also.
in the night.
In that night, Madam.
Where is that statement?
At night, I have not specially mentioned, but. Well, 4 or 5 occasions, Madam, in the night also, Madam, they have visited. I will go, but in my PM's photo, Madam.
Malad, on 24/8/25, along with Vishwajit Saikia and both occasions, the concerned police officer asked him to go after taking necessary formality. So, Malad,
But even then, Madam, in the night
Where,
also.
where?
Malad, last line of page 5, on 24/8/25, along with Vishwajit Saikia and both occasions, the concerned police officer asked him to go after taking necessary formalities. So, police
That is also there, Madam. But even then, when after that, Madam, they have visited. Madam.
some more investigation may be there, Malad.
But that, Madam, I will cooperate, Madam. But I am the victim, Madam, not the, Madam, accused. I will cooperate, Madam. I have, even, Madam, I appeared, Madam. And I appeared, Madam, I will appear.
Heard Mr. A. Konikar, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Chiranjit Das, who is apprehending his arrest in connection with Sila Patar PS case number 176/25 under section 118 within bracket 2 of BNS, read with section 27 of the Arms Act 1959. The gist of accusation in this case is that on 28/2025, one Rituraj Das had, SI of police, had lodged an FIR before the officer in charge of Silapatar police station, inter alia, alleging that on that day at about 10:35 PM, the police received a phone call stating that wherein the caller stated that they are in danger. Please help us, within inverted comma. Accordingly, after some time, 4 persons, including the petitioner, arrived at police station in a Fortuner car. And it came and narrated that one Vishwajit Saikia had accidentally pulled the trigger of the pistol which he was having, and thereby one Ganesh Lal Kumawat and the present petitioner got injured. Stop. Learned counsel for the petitioner has submitted that though on bare perusal of the FIR, it appears that it would reveal that the petitioner is a victim in this case. However, the police has been visiting the residence of the petitioner during night hours, and in spite of the fact that he had appeared before the police on 24/8/2025, along with Vishwajit Saikia, and he was allowed to go. Stop. He submits that the act of police visiting the residence of the petitioner during night hours has raised an apprehension to the petitioner that he may be arrested in connection with this case. Hence, he has prayed for grant of anticipatory bail. On the other hand, learned additional public prosecutor submits that there is no apprehension of the petitioner getting arrested in this case, as the FIR itself reveals that the petitioner is a victim in this case. I have considered the submissions made by learned counsel for both sides. Though the petitioner appears to be a victim in this case, however, the fact that the police received a phone call from a caller on the date of incident seeking help and informing police that they are in danger raises some doubt in this case, and for which perusal of the case diary would be necessary. Hence, call for the case diary. Let this matter be listed on 24.
On 16, my other case is also fixed on 16, page item 11. Same FIR.
On 16/9/2025, stop. However, if before arrival of the case diary, the petitioner is arrested in connection with this case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. List accordingly.
Deep load. May I please?
Case number 15 is the particular portion of the FIR. I am not a named accused, but 35 fee notice has been served to me to appear before IO. The fee on it is today.
Why
Even
have you not appeared?
My lord, I have apprehended him for arrest, and so I am
Why?
requesting this. Then
they are served notice under this section. To examine.
This
They have
service of
notice.
notice itself means that they don't intend to arrest you.
My lord, I am ready to appear before that. It is interim protection may be given.
Interim protection is,
To appear before the IO, if it requires.
In this case.
In this case, my lord,
Study of some cases.
the page number 18. During the investigation, some other persons has been declared as absconder, but my name is not here. Page number 18, clause number 2. Koilan Pator, Hirok Gogoi, Obhijit,
then why are you apprehending?
maybe they are stating that many other persons are involved. I don't know why I've been served with this notice, my lord.
Otherwise, that huge amount of iron small was sold to several persons.
I am not.
And,
Heard Mr. G. Pathak, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Shri Hirok Jyoti Hajorika, who is apprehending his arrest in connection with Sonapur PS case number 130/2025 under section 303 within bracket 2/317 within bracket 2/318 within bracket 4/61 of BNS. So the gist of acquisition in this case is that on 18/8/2025, one Pinku Kumar had lodged an FIR before the officer in charge of which police station? Sonapur Police Station, inter alia alleging that on 12th August 2025, the informant hired a 14-wheeler open-body truck bearing registration number AS01JC5643 to transport 16.5 tons of thin sheets from Kamarkochi godown to Silchar. Stop. The driver who was assigned to take the consignment to Silchar was Utpal Das. Stop. However, it is alleged in the FIR that the consignment did not reach its destination, and the driver and the mobile phone of the driver was found to be switched off. Hence, a suspicion was made that the goods in question were stolen. Learned counsel for the petitioner has submitted that the petitioner is in no way involved in the offense alleged in the FIR, and he has not been named in the FIR also. However, he has received a notice under section 35(3) of BNSS from the police of Sonapur Police Station, asking him to appear before the police today, that is 3/9/2025 at 10 AM. However, learned counsel for the petitioner submits that as the case involves non-bailable offense, the petitioner apprehending that he may be arrested if he appears before the investigating officer has defaulted in appearing in pursuant to the notice under section 35(3) of BNSS. And now he apprehends that if he appears before the investigation officer, he may be arrested. Case diary would be required or disposed of. I have heard learned. Stop. I have perused the materials available on record. Let us call for the case diary.
Otherwise, let's solve differently.
Why here?
Mm.
Let the case diary be called for. Listing. List this matter on 24th of September. However, in the meanwhile, the petitioner is directed to appear before the
My lord. 24, I may not be available. So 23, my lord.
23. Mean directed to appear before the investigating officer of Sonapur PS case number 130/2025 within 7 days from the date of this order and cooperate in the investigation. If he does so, in the event of his arrest in connection with the aforesaid case, he may be allowed to go on interim bail of rupees 30,000 and remaining eligible list accordingly.
Madam Chair.
Yes, Your Lordship. The matter is in appearance stage. Tomorrow is the next date. In appearance in 16/7.
So, statement of the Habibur Rahman.
What is to be done, Mr. Parash?
Otherwise 21B, but husband is absconding malad since malad then malad.
Where is the FIR?
FIR is at page number 13, relevant portion, page number 16. May I, Your Lordship?
As per FSL, the heroine is positive test for heroine malad. Reflected in the order, page 35.
Heard, Mr. What is your name?
Amar Sudhir.
MR Sodiel, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Fatima Begum, who is detained behind the bars since 26/5/2025 within bracket for last 100 days in connection with NDPS case number. What is the case number?
55/24.
55/2025 corresponding to Dholai PS case number 78/2025 presently pending before the court of London.
Special Judge.
Special Judge
Kachar.
Kachar. Stop. Learned counsel for the petitioner has submitted that on the basis of an FIR lodged on 26/5/2025 by
Yamali Gogoi,
one Shamali Gogoi
WSI.
before the officer in charge of Dholai police station, inter alia, alleging that during search of the house of the petitioner, 101.43 grams of suspected heroin was recovered therefrom, an investigation was initiated and ultimately on completion of investigation, charge sheet was laid against the petitioner and her husband under section 21B/29 of the NDPS Act 1985. Stop. Learned counsel for the petitioner has submitted that. What is your plea?
I am not involved in the crime. My husband is the prime accused in this. And in his absence, I have been arrested after the
Has
seizure.
submitted that though the seized contraband was recovered from the house of the petitioner,
It is recovered
How?
from the storeroom away from the house, Your Lordship.
How it,
from the premises of the petitioner house. However, she is not involved in the offense alleged in the case. He submits that the husband of the petitioner, against whom also FIR has been, charge sheet has been laid, and who is absconding, might be involved in the offense alleged.
it's from the storeroom, it is seized. The storeroom, how can be away from the house? Storeroom.
Within the campus, but not within the premises, I mean residential premises. It is a little different part.
Stop. Learned counsel for the petitioner has submitted that though the petitioner has been detained behind the bars for last 100 days, however, due to the absence of the co-accused, the trial is yet to commence and charges are yet to be framed against the petitioner. He submits that the quantity of contraband seized in this case is of intermediate quantity, and therefore the embargo of section 37 of NDPS Act is not applicable to this case. He also submits that the petitioner is ready to cooperate. Where do you stay?
Your Lordship, Dholai himself,
Petitioner is a permanent resident of
Lailapur Forest Village, UNPF Dholai.
Lailapur Forest Village under the jurisdiction of Dholai Police Station, and she is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor, you are opposing,
Yes, from the house. it is
has
seized
opposed
from
the
eight
grant
numbers
of
of
bail to the petitioner on the ground that charge sheet has been laid also against the petitioner along with her husband, and there are sufficient materials
And more particular, husband is absconding till now.
against the petitioner in the records.
My lord, one small submission also. I have 3 minor children also.
Learned counsel for the petitioner also submits that the petitioner is the mother of 3 minor children. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. In this case, apparently the trial is yet to commence due to the fact that the husband of the petitioner is absconding. However, considering the fact that the petitioner has been detained behind the bars for last 100 days and she is ready to cooperate in the trial, her custodial detention does not appear to be necessary if she cooperates in the trial. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned
Special Judge.
Special Judge Kachar with following conditions. Trial conditions. This bail application is accordingly disposed of.
Deeply obliged.
May at least a lot. Although the case was, my lord, proceeding was initiated under POXO Act, my lord. Now kindly see, just for a moment, my lord, kindly see page number 3, para number 3, my lord. How this case is final report was filed by the police after investigation, and therefore, thereafter, my lord, on the basis of protest petition, the investigation, re-investigation was started.
Now, since when you are behind the bars?
My lord, I am behind the bars since 37/20/25.
We are calling for the case then.
My lord, kindly for a moment, page 3.
Now, what is your submission?
My submission is that, my lord, the offense was committed 2 years back. On that time, the FIR was lost. That FIR was investigated, charge sheet was filed. So I was charge sheeted, my lord, and this, by showing as an absconder. And someone has received, on receipt of someone, I appeared. Subsequently, my lord, after 4 months, again a complaint lodged on the basis of same cause of action. Thereafter, my lord, police, that on the basis of that complaint, it is forwarded to the police station. Police registered the case, and on registering the case, police found that the cause of action and the earlier case was same incident. Thereafter, my lord, upon investigation, police filed final report. Now, thereafter, my lord, after 2 years, on the basis of that final, after appearing on final report on protest petition, re-investigation is started. So, my lord,
Your earlier case is pending.
earlier case is pending. It is charge sheeted. So how this case can be continued?
Where is the FIR in earlier case?
FIR is not, I have not found, madam.
Then how will we verify?
My lord, kindly, it is everything on final report, madam. It is in record on final report. Kindly see the final report, madam. The how police is, madam, filed, madam. For a moment, kindly see page number 3, para number 3, madam. Just I would like to read, madam.
No, that is your submission.
My lord, this submission based on record, madam. My
No,
lord,
that you have already submitted.
my lord, an exact 2, kindly see, page number 24, final report. This is the translated version, madam.
Page number?
24, madam. An exact 2.
You want to say that for the same offense?
Same offense, police saying, madam. Not, I am not, the investigating authority is saying.
Then why the magistrate took cognizance?
This is the reason. So, police also said that 161 statement was recorded at that time.
What was the date of alleged offense?
This, it is, my lord, in the year 2023, my lord.
What was the date?
Date, my lord, I'd like to.
Now, second matter is pending investigation.
This is now investigation. Again, my lord, on the basis of protest petition.
So is there order or order to be?
Yes. Page number 44.
Where is the order?
Page
Oh.
number 44, my lord. Page 42, 43, and 44.
Where is the order?
Page 42, my lord, may I read? And
It does not reflect anything.
my lord, page number 29, my lord, kindly see. Final report bearing roll number dated 30/11/2023, along with the case diary of the instant case has been received today. Let the same be taken with the instant case report. Thereafter, page 30, my lord. page, order dated 15/3/2024.
Issue
Informant and victim are present and have submitted a joint petition.
Next page.
Though the land special PP and their
15/3/24.
willingness to contest the case with cause sharing. Had the informant, victim and land special PP peruse the case record, let a fresh investigation be carried out in the connected PS case by a different IO than the one who has submitted a file. Informs Pandana Police Karimganj officer in just Karimganj police for doing the needful.
This is the order.
This is the order, my lord, page 13.
And where is that? That earlier case is pending in respect of the same.
In respect of the same, my lord, I have no record, not I have annexed, but it is the earlier
Let the
case
record be called.
earlier-
That has to be verified.
Let the record be called for, my lord.
that my lord, this is, everything is reflected on the police, case number, everything is reflected on the final report of police, ma'am.
That is not believed by the trial court,
Yes, my lord.
and therefore investigating officer has been
Without any-
changed.
Yes, my lord.
So
Record I have.
to verify that
That the
records,
actual case may be record also may be called for, my lord. Yes, sir.
We'll call for the CD, my lord, this, Karimganj 9.
what is the
And
case number of the
49.
earlier case?
Case. 820, it is, my lord,
Where have you mentioned?
Karimganj PS number, page 24, my lord. Page 24. Karimganj PS case number 823/2023. And the CS number also 823/2023. This is the earlier case, ma'am.
Heard Mr. H. R. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner,
23.
namely Razuddin alias Maharaj Hussain, who is detained behind the bar, who has been detained behind the bars since 30/7/2025 in connection with special POCSO case number 260/2023 arising out of Karimganj PS case number 894/2023 under section 120B/366A/376(3)/417/34 of the Indian Penal Code, read with section 4/6/8 of the POCSO Act. Learned counsel for the petitioner has submitted that in respect of the offense alleged in the FIR, the police had earlier submitted a final report on the ground that for same offense, another case was registered, that is Karimganj PS case number 823/2023, and in which charge sheet has been laid bearing charge sheet number 823/2023 on 31/10/2023. What is the sessions case number?
That, my lord, I was not furnished, my lord.
Then how will we know?
But it is, my lord, the police is saying that on the same offense, a final report, my lord, it is everything, my lord, elaborately discussed by police, my lord.
How to call the?
No, you don't know what case is pending against you. You are facing the trial. It is your submission that a case is pending against you. What is the case?
I'll furnish, my lord.
You file an additional affidavit.
And I'll furnish after some time, my lord, regarding the number.
But you have not made any statement to that effect.
The number is not furnished, my lord. However, it is charge sheeted, my lord. Someone has issued, my lord. It was,
Where is the number? What is the detail about?
I will furnish, my lord.
Heard Mr. H. R. Chaudhary. learned counsel for the petitioner submits that he may be allowed to file an additional affidavit to bring on record certain facts. The prayer is allowed. Let this case be listed. When, how much time you need?
Tuesday, madam.
Let this case be listed again on Tuesday. 9th of September.
Okay.
Lordship, can you say lordship idea about a page 34?
This is second bail application.
Second means minor regular because 20% cited as minor PW. Out of the 6 witnesses were examined at that stage when your lordship, that is close the matter. And thereafter, not a single witness has been examined till today. Your lordship, what is page 34, it starts. And last part, can we see? Page 36. There might be stated 6 witnesses, actually might have in fact, out of 14 witnesses still to be examined.
Now, what is your submission?
My submission matter how long only might have, whatever may be the faith of the case matter, how long will remain in that way matter, because that delay in trial also, it is also my right matter. Article 21. Page 54, you lost, kindly have a look at page 54, list of the date. After your lordship's order, these are the order sheet I have, and that's fine. Order sheet. 6 occasions, PWs remain minor absent. And on 2 occasions, minor because non-ability of some MRPA, that was my.
How many total witnesses are there?
22-0. Page 16 is
Out of those, how many have been examined?
only 6 that which was already observed. Thereafter, not a single witness observed.
We'll call for a report from the trial
It is
court.
there, but I have given everything at page 54. Page 54.
What was the date of rejection?
Yes. Rejection date 21/5/25. And thereafter, page you can
3
see
months.
25, page 6, page 54. After you lost the page 3625, fiction 17. 17 production evidence, 17 present but not examined. Page 55. 14.7, 2 PW present but not examined. 28.7, PW absent. 11.8 absent. Then 6, 11 absent. Fixed on 2.9. 2.9 yesterday it was there. Again, it is fixed on 16. Yesterday also nobody was
16/9.
69.
16.9. Yesterday also nobody was present.
Yes.
Delay, otherwise. It appears that,
We will call for a report. Why the trial court is getting difficulty in examining
Page 14, my lord, yes, sir.
What did you
Page
have the
30
information
after 16th.
after 16?
After
Page 36, my lord, in para 14. In the earlier order, you mentioned that it appears from the record that 6 more independent witnesses are yet to be.
That is, I think, matter because of the wrong information given to your lordship. Actually, 20 total in the chart sheet.
No, out of those 26 may be independent witnesses.
Independent witness maybe.
Others.
But total 21. 14.
Heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Mr. A. M. Alamgir, learned counsel for the petitioner. How many petitioners are there? Only one.
One petition.
This application for bail under section 483 of BNSS has been filed by the petitioner for the second time, seeking his bail in connection with Sessions case number 28/2024 pending before the Court of London. Additional Sessions Judge Romia Kamrup. The petitioner has been detained behind the bars since 18/5/2024
As of now, my lord, 465 days.
within bracket for last 465 days. Stop. Learned counsel for the petitioner has submitted that. Learned senior counsel for the petitioner has submitted that the petitioner had approached this court on an earlier occasion and his prayer for bail was rejected on that occasion by order dated 21/5/2025, passed in bail application number 1327/2025. While rejecting the prayer for bail, this court observed that as 6 more independent witnesses were yet to be examined at that point of time, and the petitioner was given a liberty to approach the trial court again after examination of remaining 6 independent witnesses. So learned senior counsel for the petitioner has submitted that there are total 20 listed prosecution witnesses in the charge sheet, and out of which only 6 have been examined. He further submits that after rejection of the bail application by this court on 21/5/2025, the Sessions case number 28/2025 was listed before the trial court on several occasions. However, not even a single witness have been examined till date after the said date. He submits that on one occasion, 2 prosecution witnesses were also present before the court. However, due to non-availability of the seized materials, the prosecution witnesses could not be examined. He therefore submits that the petitioners who are languishing behind the bars since the date of their arrest may be allowed to go on bail as date of his arrest may be allowed to go on bail as he is ready to cooperate in the investigation. Stop. It appears from record that by order dated 21/5/2025, the prayer for bail was rejected mainly on the ground that some independent witnesses were yet to be examined. However, it appears that since the date of rejection, not even a single witness has been examined by the trial court in last 3 months. Stop. In view of above, let a report be called for from the trial court as to why the trial, as to how many more independent witnesses are yet to be examined in the aforesaid case, and why the trial is not progressing. Stop. Let this case be listed on 17, not 17.
18.
All of our officers. Peace out.
18 is my lord. 18 is Thursday.
The date is fixed on 16,
16.
so it should be after.
2 days after, but we can collect a copy also. If not. 16 is Tuesday,
22,
22.
Monday. Let this case be listed on Monday. Registry to furnish a copy of this registry to send a copy of this order to learn additional session just now for complaints.
Item 12.
May it please your lordship. It's a regular bail, my lord. Your lordship will find the FIR, my lord, at page 12, my lord.
What is the acquisition?
My lord, some legal points, my lord. One legal point is there, my lord. So this is a case, my lord, of Dokmoka PS case, my lord. So some, my lord, IMFL bottles were recovered from a truck, my
What
lord.
was recovered?
IMFL bottles, my lord.
Okay.
That your lordship will find, my lord, at page 12, my lord. Below, my lord, 10 cartons of 750 ml of Royal Stag, 5 cartons of 375 ml McDowell, and 5 cartons of 180 ml of McDowell's, my lord. Now, my lord, before I submit, my lord, the lordship may kindly have a look, my lord. The petitioner was earlier arrested in a case, my lord, that your lordship will find at page 18, my lord, 18, my lord. I'm just showing the forwarding report, my lord. The lordship will see, my lord, my name appears at number 6, my lord, Kasem Ali, my lord. It is with regard to Dilai PS case number 46.
Page number?
Page number 18, my lord, 18, my lord, Annexure 3. Lordship got it, my lord.
Yes.
My lord, my name appears at serial number 6, my lord. Next page, my lord. The backgrounds of the case, my lord. On 23/8/25, complainant so lodged an FIR in this police station. On the same day, about 3:30 p.m., a container truck bearing registration number so was coming from Manja side and heading towards the Imphal Manipur side was stopped for normal checking. The driver of the said container identified himself so. And the driver asking the driver to produce the documents of the loaded goods, he produced a challan of matchbox, pesticides, and other articles. But it was suspected that some other items were concealed inside the container. While thorough checking, about 350 cartons of Kingfisher can, 250 cartons of Tuborg, both of Arunachal Sale IMFL, have been recovered, and asked the driver of the truck to produce the documents of the loaded goods, but he could not produce any supporting document. And accordingly seized the carton containing beer along with the other articles as per challan, and also apprehended the driver, namely Saddam Hussein. After the driver was arrested, my lord, he revealed our name, my lord. Now your lordship will see the reasons for arrest, my lord. Serial number 6, my lord. If they were released on notice under section 35(3) BNSS, then their presence before the honorable court is not sure. This is the reason given by the IO, my lord. So on 26, my lord, now lordship will turn to page 28, my lord. 28, my lord, is the order dated 26/8/25, my lord. Below, my lord, accused person, my lord, my name is there, my lord, Mohammad Kasem Ali, my lord. We have been produced before the court, my lord. So next page, my lord. Before me, produced, last line, were produced before me on being arrested by the police of Dilai PS in connection with the instant case for offense under section so and so, my lord. Now the last paragraph, my lord, coming back to the case in hand, as the allegation is for offense which contains punishment, imprisonment, which is less than 7 years, hence the question of complying the direction, my lord. There is a mistake in the pagination, my lord. The lordship will now turn to page 31, my lord. Laid down by the Honorable Supreme Court in case of Arnesh Kumar versus State of Bihar, reported in so and so. Now below your lordship will see, my lord, the third paragraph. The IO had submitted that the notices under section 35(3) of the BNSS were not served as the accused person may not cooperate with the investigation of the case. Peruse the case record and it is seen that the offense is punishable up to 7 years and no notice under section 35(3) of the BNSS is served to the arrested 7 accused person as named above. Further, in the forwarding report, in the reasons arrest, point 6, it is mentioned if accused person were released on notice under section 35(3) BNSS, then their presence before the court is not sure. It is seen that the IO of the case has not complied with the direction laid by the Honorable Supreme Court in the case of Arnesh Kumar versus State of Bihar. Now, my lord, sorry, my lord, the page in it. Now the previous page, my lord. Previous page 30, my lord. Consequently, the court deems it fit to enlarge the accused person. So on the very first day, my lord, they were allowed to go on bail, my lord. Now your lordship will see the last line, my lord. None of the accused person had furnished bail. Now your lordship will turn to page 32, my lord. None of the accused person has furnished bail bond, hence issue custody warrant. So as they could not produce the bail bond, my lord, they were sent to the, my lord, jail, my lord. So thereafter, my lord, on 27th, my lord, when we came out from the jail, my lord, the police investigating agency, my lord, of this Dokmoka case had arrested me, my lord, from the front of the, my lord, jail, my lord. Now, your lordship, my contention, my submission before your lordship, my lord, they have filed the forwarding report in the Delhi PS case. That is, my lord, at page 18, my lord. They could have stated, my lord, that there are other cases pending against me. They have not done so, my lord. Their duty ought to have been, my lord, they have to say, my lord, that there are a number of cases or these cases pending against you. They have not done so, my lord. And now, my lord, the forwarding of this case, my lord, that is at 43, my lord. Page 43, my lord. Here also, my lord, next page, my lord, 44, my lord. From below, my lord, second paragraph, my lord. Subsequently, on 27/8/25, I have apprehended the above mentioned accused person from Difu and brought to the Dokmoka PS for interrogation and further legal action in connection with the instant case. During interrogation, they have confessed about the transporting of illegal liquor to Imphal, Manipur, a dry state where selling and consuming alcohol is banned for selling purpose, and also confirm about joint business of illegal liquor transporting and selling with so and so, my lord. Now the reasons of arrest, my lord. The next page, my lord, see, lordship may kindly see, my lord, page 45 at serial number 4, my lord. The arrested accused person Kasem Ali, owner of the truck bearing number so and so, who loads the illegal liquor in his own vehicle from so and so to Imphal, my lord, and earns an amount of rupees 2 lakhs for each delivery. And number 8, my lord. If the accused person is not arrested and forwarded before your court, he might flee away and his apprehension in future could not be ensured. Then 10, my lord, to prevent such person from committing any further offense. And lastly, my lord, for proper investigation of the offense. But I am relying upon the apex court judgment, my lord, that Uday Chand's case, my lord.
The earlier case was of which police station?
Earlier case was of Delhi.
This one?
This one is Dokmoka, and is under the same district, same SP, my lord, same superintendent of police.
Yes.
Well, paragraph 5, my lord. Well, he has to be apprised, my lord. And one more judgment, my lord, on one more order.
Any other ground?
Any other
ground?
Any other ground?
Whether 35(3) was complied with in this case?
I think to my submission, no, my lord.
Why?
They have not given the notice also. That's why I have pointed, my lord, this is the case, my lord. Come to case. Huh? I'm sorry, my lord. I'm relying upon this one, my lord. Kamal Datta's case, my lord. Kamal Datta's case, my lord, last page, my lord, 521. 521, my lord, left side, my lord. Left side, my lord, second paragraph, my lord, last 3 line, my lord. Arresting the accused in a different case from outside the court where he was granted bail without disclosing to the court about the need to arrest him. My lord, in the forwarding report in the Delhi case, my lord, not only they have to tell me that another case is pending against you, also, my lord, they have to say why, what is the need to arrest me?
Yes, Mr. Parash. In this case, whether 35(3) was complied, no.
No, no.
Then to verify that we would require case diary.
That your lordship.
Though they have mentioned 3 grounds,
Yes, my lord.
Grounds.
but they, whether it is supported by facts or not.
But that your lordship will see page 44, my lord. Reasons for arrest, my lord. E, my lord. Last 1, 2, 3, 4th line, my lord. As unless such person is arrested, his presence in the court whenever can be ensured, or for non-compliance to a notice under section 35(3) of the BNSS. I was in
No,
the,
in this case, notice was not at all given.
not at
So why it was dispensed with?
all.
Case diary would be required.
Well, what happened, my lord? In the Delhi case, my lord, I was produced before the judicial magistrate first class, my lord. But in the Dokmoka case, the next day I was produced before another court, my lord, CJM, my lord. But it is their duty to, my lord, in the forwarding, my lord, the earlier case, they ought to have given me, my lord.
Let us, short date may be given, my lord, to be.
There appears to be violation of
Yes, my lord.
heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner Kasem Ali, who has been detained behind the bars since 28/8/2025 in connection with Dokmoka PS case number 20/2025
No, sorry.
under section 3 within bracket 5/305/317 within bracket 2/323/61 within bracket 2 within bracket small b /337 of BNS, read with section 53 within bracket 1 within bracket small a of Assam Excise Act 2000. Learned counsel for the petitioner has submitted that the petitioner is seeking bail in this case mainly on 2 grounds. First of all, before arresting the petitioner in the instant case, he was arrested in connection with
Delhi PS
Delhi PS case number 46/2024.
25.
2025. And the FIR in the instant case. Instant case has been filed on which date?
18/8/25.
18/8/2025. It is submitted by learned counsel for the petitioner that the petitioner was granted bail by the Court of Learned Judicial Magistrate First Class Bokajan in Delhi PS case number 46/2025 on 24/8/2025. However,
26.
26/8,
page 30, madam, 26/08/25.
on 26/8/2025. However, he submits that in the instant case, FIR was lodged before 26/8/2025, when the petitioner was detained behind the bars. However, the information regarding his involvement in another case and necessity of arresting him in the present case was not given to the Court of Learned Judicial Magistrate First Class, Bokajan, by the police when he was granted bail in Delhi, case number 46/2025. Learned Counsel for the petitioner submits that same is in violation of the guidelines issued, violation of the observations made by the apex court in the case of Uday Chand versus and others versus Sheikh Mohammed Abdullah, Chief Minister of J&K and others, reported in 1983 to SCC 417. Learned Counsel for the petitioner has submitted that the second ground on which the petitioner is seeking bail in this case is that though the offenses involved in this case do not entail punishment more than 7 years. However, no notice under section 35 within bracket 3 of the BNSS was served on the petitioner before arresting him in this case. He further submits that though in the forwarding reports, grounds for arresting the petitioner in the instant case have been mentioned by the investigating officer. However, no facts on the basis of which the arresting authority was satisfied regarding existence of conditions mentioned in clause A to clause E of section 35 within bracket 1 within bracket B within bracket Roman 2 of BNSS have been stated in the forwarding report, and therefore he submits that the guidelines of the apex court issued in the case of Anesh Kumar versus State of Bihar has also been violated in this case. Stop. To appreciate the submissions made by Learned Counsel for petitioner, perusal of the case diary of Dokmoka PS case number 20/2025 would be necessary. Hence, call for the same. Let this case be listed again on
Tuesday, 10th, 9th.
on 9th of
Because my wife is expecting, my lord.
9th of September.
My- And the next case also, my lord, same, there will be petitioners, my lord. Same,
Same case.
same. Only petitioners, my lord. Keta ase tate? Two. There are two petitions.
Heard Learned Counsel for the, heard Mr. N.J. Datta, Learned Counsel for the petitioner, also heard Mr. K.K. Parashar. Learned Counsel for the petitioner has submitted that in a connected case, that is earlier case, item number Kimana said,
12.
in a connected case, that is bail application number 2885/2025. This court has called for the case diary on 9th of September, and therefore he prays for listing this matter along with the said case. The prayer is allowed. Let the case diary be called for. Let this matter be listed along with bail application number 2884/2025 on 9th of September.
I'm obliged, my lord.
Item 48 for supplementary it is
Item number
May I please
Yes.
your lordship, it's a 2020 FIR, your lordship, at page 10. Now in the year 2025, they have issued a 41A notice, and I have been asked to appear. The FIR is at page 10, if I may read.
Two thousand and twenty-five, they issued 41A or 35-3.
They should issue 35-3, but they have issued 41A, your lordship, that is at page 25. Very surprising, I noted.
You appear?
Yes, your lordship, give me protection, please.
What is the accusation?
There was some 9,13,506 was fraudulently siphoned off from the account of the complainant.
By whom?
Yeah, it's an unnamed FIR. Your lordship. Subsequently, they arrested 5 people and they got bail in 2020 itself.
Who are you?
I am the brother of the person who was arrested. I am nowhere connected with the case. I have been summoned. I'll appear.
What is the name of your brother?
Brother is your lordship, Tayyum Laskar. That is, I have mentioned it at page 5, your lordship. At para 5, page 3.
He has been allowed to go on bail.
Yes, your lordship. He was given bail by the Sessions Court way back in 2020.
Where is the notice under 35-3?
That is at page 25, 41A notice.
But
What was the date?
Date is, your lordship, I've been asked to appear tomorrow.
You appear tomorrow.
27/8, my lord. That is in the signature, my lord.
Then you appear tomorrow.
Give me protection, your lordship.
Otherwise, my lord, one thing is that, my lord, money involved, my lord, 9,13,000. Siphon from the, my lord, ATM card, my lord. Whether he
We don't know
involved,
now
my lord.
regarding his involvement. He may be involved also later on. Okay. Heard, Mr.
DK Agarwala.
D.K. Agarwala, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Sharimuddin Laskar, who is apprehending his arrest in connection with Rongya PS case number
Right.
944/2020 under section 120B/420/379 of Indian Penal Code, read with section 66C/66D of the Information Technology Act. The gist of accusation in this case is that when the affair was lodged
9/10/2020.
on 9/10/2020, one Paresh Chandra Deka had lodged an FIR before the officer in charge of Rangya Police Station, interiorly alleging that someone has fraudulently withdrawn an amount of 9,13,506 from the account of the informant. Stop. Learned counsel for the petitioner has submitted that the FIR was filed way back in the year 2020 and the petitioner has not been named in the FIR. He further submits that the petitioner has received a notice under section 41C of CRPC, 41A CRPC, asking him to appear before the CID Police Station on 4/9/2025. Stop. He submits that the petition, learned counsel for the petitioner submits that the petitioner is in no way involved in the offense alleged in the FIR. However, in connection with this case, his brother Tayyum Laskar was arrested in the year 2020, and later on he was granted bail by the court. He further submits that 4 other accused persons were also arrested in connection with this case, and all were granted bail in the year 2020. He further submits that as the offense, as non-bailable offenses are involved in this case, he apprehends that if he appears before the investigating officer without any protection, he may be arrested. And therefore he prays for allowing the petitioner to go on interim bail, to go on anticipatory bail. On the other hand, learned additional public prosecutor submits that prays for calling of the case diary. The prayer is allowed. Let this matter be listed for case diary on 22nd. When you will appear?
Tomorrow itself.
In the meanwhile, petitioner is directed to appear before the investigating officer of the case in pursuant to the notice received by him tomorrow at the given time in the notice, that is at 11 a.m. on 4/9/2025. Stop. And cooperate in the investigation. Stop. If he does so, in the event of his arrest in connection with the aforesaid case, before arrival of the case diary, the petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2, list accordingly.
Just one thing, your lordship has mentioned that all the 5 accused were given bail in 2020. They were given bail in 2021.
2021. Okay.
Much of.
My lordship, may I pray that this matter may be taken after 2 weeks, my lordship? If I have challenge with regard to the bar under section 468 of CRPC, the lead judgment being Sara Mithu, I couldn't collect the Darshan Singh, my lordship, with regard to the institutional proceeding.
No, what is the prayer?
After 2 weeks time may be granted, I will collect some judgment.
Heard Miss S.G. Barua, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner seeks an adjournment for 2 weeks to enable her to produce some authority in support of her case. Stop. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Mass obligation, my lordship.
Item 24.
This case, my lord. I'll file an additional affidavit on 21/8/2025. That is not on record, ma'am.
Let that come on record.
On Tuesday, madam, with the additional affidavit.
Heard Mr. H.R. Chaudhary, learned counsel. Case diary is there?
Scan copy.
Okay. Heard Mr. H.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner submits that the petitioner has filed an additional affidavit on
21/8/2025.
21/8/2025 in this case. However, same is not on record, and therefore prays for calling the same. Stop. Considering the submissions made by learned counsel for the petitioner, the registry is directed to place the additional affidavit filed by the petitioner in the record on the next date fixed, that is 16/8.
My lord, kindly Tuesday, my lord,
Tuesdays,
Tuesday.
16/8. Otherwise, it will not reach on Tuesday.
25.
Maybe you know, but there in this case, Lordship. May I place some important state, Lordship? In this case, Lordship, the affair was filed on 28/7/2022, Lordship. And he was arrested on 4/9/2022,
28,
28/7/2022. And arrested on 4/9/2022. And Lordship.
how many days you are behind the bars?
3 years, Lordship. Charge sheet submitted on 17/1/23. And charge framed on Lordship 27/7/23. And Lordship, last witness examined on 5/10/2024. That is PW 19, Lordship, out of 56 witnesses. And Lordship, last rejection order dated 4/3/2025. Earlier it was rejected.
Where is the rejection order? What is the ground? What is the case?
98, Lordship, rejection order, page 98,
UAPA?
UAPA, Lordship. Lordship, after rejection, Lordship, none of the witnesses examined, Lordship, after rejection, Lordship. Rejection order, page, Lordship, 98, Lordship. And in this case, Lordship, total 15 persons are there, Lordship. Out of 15, Lordship, 13% already granted bail, Lordship, by this honorable court as well as Lordship trial court, Lordship.
What is your name?
Mamunur Rashid, Lordship.
Mamunul
Mamunur Rashid,
Rashid. Where is the last rejection order?
page 98, Lordship. And this application was filed on Lordship 20/05/2025, Lordship.
On what ground it was rejected? That there are materials.
Lordship.
On what ground? There is a bar in 43D.
43D.
What is your submission to overcome that bar? Prolonged incarceration.
Lordship, prolonged incarceration. It is there, Lordship, I was stated in my petition.
No, what is to be done? You are ready?
I am only on Lordship consideration, period of Lordship, very long incarceration, Lordship. And
When is the last? What is the accusation against you?
Lordship, FIR, Lordship. I am not the Lordship FIR named accused, Lordship. FIR will find Lordship, page 18, Lordship.
Or we call for the status report, up-to-date status report. Heard Mr. I.U. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, heard Mr. B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner has submitted that though there is a bar under section 43D of Unlawful Activities Prevention Act 1967 for regarding grant of bail in cases involving offences under Unlawful Prevention Act 1967. However, the petitioner is seeking bail on the ground of violation of his fundamental rights guaranteed under Article 21 of the Constitution of India due to prolonged incarceration in this case. He submits that the petitioner has been detained behind the bars for last 3 years and only 19 out of total 56 witnesses have been examined till date. He further submits that the prayer for bail of the petitioner was earlier rejected by a coordinate bench of this court on 4/3/2025 in bail application number 100 of 2025. However, since that date, not even a single witness has been examined by the trial court. So, on the other hand, learned additional public prosecutor has submitted that the up-to-date status of the pending trial of Sessions case number 10/2023 is not before this court. And hence, he prays for calling of an up-to-date status of the pending trial. So, let the status and let an up-to-date status of the pending trial of Sessions case number 10 of 2023 pending before the Court of Learned Session Judge. Which court it is pending? Session Judge Borpeta be called for. Let this, when is the next date fix? Date, trial court?
I have to take
Date of the due. Let this case be listed again on 18/9 of, or we may give a longer date.
Lordship may fix a short date. Lordship, in the meantime, Lordship, I
Oh,
may file.
Okay, 18/9,
Certified copy, Lordship,
18/9.
deeply of my Lordship. 26.
These are not circular, but we have a California extra 1 million as R. With 7 million.
Yeah, sheeted case.
Yes. No.
Victim has been examined.
No.
At what stage the case is pending?
For evidence. Now today it is 246 days. I arrested 1 million 12 yes 25th of December 24. So it is not examined, that is.
Whether evidence has started or not.
It has started, Lordship, but no one has not examined as of yet, Lordship.
No one has been examined.
17/3/25 charges were framed, Lordship.
Which court? Buxar.
And Lordship, as per the records, Lordship, the last date was 19/6/25. It was fixed on 19/6. So what happened on that
After
day?
19/6,
No, on that day also, Lordship, what happened, we don't know, Lordship. That is not on record.
when is the next date fixed?
I have no.
No idea.
I will jail, Lordship.
Yes, you are appearing for the victim.
Information.
Have you received? Have you received summons from the? Oh, what is your submission?
I started, but I have nothing to say. I have no objection. Earlier also,
And
they have-
The
There is no
victim, Millard, my submission.
You don't have any objection? Why? Your father or mother?
Author of the victim.
Earlier also, my lord, in the trial court also, my lord, they have raised no objection. In the court of case, my lord, 29/4/2025, my lord.
Where is the FIR? Let us see.
FIR Millard, page 7 Millard. And girl is Millard about 17 years Millard. And they have love affairs with each other. Married Millard, page 17. And particularly Millard is that is also were there.
You are detained behind the bars since 19/6/2024.
Not my hearing will even 25. Yes, 25, 12, 24 million.
For how many days you are behind?
I'm at 246 days today.
Yes, Mr. Sharma.
The offense is non-compoundable, Lordship. At least the victim needs to be examined. Lordship. And he was, Lordship, her date of birth is 10/12/2007. And altogether, Lordship, 7 PWs are there. And Lordship, this status report before your Lordship, maybe she has been examined, Lordship. A status report at least maybe called for, Lordship. Because as per the records, Lordship, it is updated till 5/6/25. After
I mean, considering
5/6/25.
that without any trial, without any. My worship, even I may be now allowed to go on bail. Let them examine, let them examine the PWs, we have no objection.
And he happens to be, Lordship, a married man with 2 children, Lordship. Even then, after that also, Lordship, he manipulated
And the victim of the
Lordship, who is a minor,
recovered,
Lordship.
her statement was recorded by the magistrate and now she is with her mother.
What is to be done?
So at least the status report may be called for, Lordship, because
My
it was
submission,
5/6/25.
long pending, 246 days in.
No, but you don't know the next date of the case.
I don't know, even if there is.
So we will call for a status report fixing a short date. Heard Mr. A. Rashid, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Also heard Mr. A. Mubarak, appearing for the respondent number 2. Stop. The learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last
246.
246 days. And considering the period of detention, he may be allowed to go on bail. On the other hand, learned counsel for the petition, learned counsel for the respondent number 2 submits that the respondent number 2 does not have any objection if the petitioner is released on bail. However, learned additional public prosecutor has submitted that since the status of trial is not known to this court, hence before passing any order, a status report may be called for from the trial court. So considering the submissions made by learned counsel for the learned additional public prosecutor, let a status report of the trial of POXO case number. What is the POXO case number?
So this number not.
That's 15.
POXO case number 14/2025 pending before the special POXO judge Baksa be called for. Let this case be listed again on 16th of September. Registry to send a copy of this order to learned special judge Baksa for compliance.
27.
Can you short it, 11th of September?
11th will be difficult. It may get listed, but it may not reach. Therefore, wait. Item number? Yes.
May I please, Your Lordship? Lordship, here in this case, the petitioner has been languishing behind the bar.
Lordship, I have prayer, Lordship. We have received objection today, Lordship. So this matter may be fixed tomorrow. We are filing
The
objection.
last occasion of Lordship, so far I can recall it, Lordship stated that if they fail to file any objection. So that will be considered the positive way for the lordship, because he has been.
When will
languishing
you
the-
file objection? When will you file objection?
Today, Lordship. We have received today and we are filing Lordship objection.
Last occasion also they took time, lordship, and he is behind the bar for last 2 years, for 5 months and 16 days, lordship.
Let them file objection. How much contraband is involved?
119 cases, lordship. All the
One
other queries has been granted bail, lordship.
We'll take it up tomorrow. Let her file objection today.
Lordship,
Heard Mr.
he handled it.
Heard Mr. K.K. Hendik, learned counsel for the petitioner. Also heard Ms. M. Deka, learned counsel for NCB, who submits that the NCB is going to file written objection during the course of the day, and therefore prays for listing this matter tomorrow. Considering the submissions made by learned counsel, the prayer is allowed. List this matter tomorrow, that is on 4th of September.
But if they do not file today also, then lordship, tomorrow it may be considered, lordship. 28.
Tomorrow you make that submission.
Lordship. Reply online, lordship.
Yes.
Lordship, in this case, accused was arrested on Lordship 10/9/2023.
How many days?
Only 2 years Lordship was only 7 days shorter than 2 years.
Yes, what is the submission?
Lordship long incarceration is there and the Lordship other ground of arrest was not communicated with the accused. With the Lordship. And the Lordship 5 witness examined during evidence before charge. Lordship recovery and seizure is very much doubtful. They did not support the prosecution case. And charge framed on 1/9/2025, Lordship, day before yesterday. Lordship, kindly have a look at.
How many listed witnesses are there?
5. A charge frame only on 1/9, Lordship. And Lordship, kindly have a look at page 34. 1 and 2, PW 1 and 2 are the
What procedure is adopted? Why evidence before charge?
So there, trial court proceeds in a different way, Lordship. Your Lordship, charge is submitted on 30/4/2024. Then Lordship, dates were fixed for evidence before charge.
But there is a judgment that sessions tribal procedure is to be adopted in NDPS cases.
Change, Lordship.
Okay. What is your submission?
Lordship, these 2 independent witnesses who are claimed to be the witness the search and seizure, they did not support the prosecution case. Lordship, kindly have a look at page 34. May I read?
Page number?
34.
Yes.
I know the complainant. I do not know the accused person who are virtually produced before me today. The occurrence took place about 3 years ago. One day, the custom official called me during noontime and asked me to visit their office. As I went to their office, they asked me to become witness in a case and handed over me some document. And in such a document, I put my signature. On the other hand, PW5 claim, investigating officer claimed that he was present while seizure was made. But according to this witness, these 2 independent witness, they attended the custom office at noontime, and the document given to them where they only put their signature. They neither witness the search nor
At the time of Lordship season, they were present. And further Lordship, ground of arrest neither communicated with his family, not to the accused person, and there is a long intercession. And the Lordship learned trial court rejected my bail prayer. Lordship, kindly have a look at Annexure 4, page 65. Ground, Lordship, paragraph number 9.
Yes.
Further, as the case in hand apparently involves commercial quantity, the rigor of section 37 of the NDPS Act is also applicable in the case. Section 37(1) B2 of the NDPS Act imposes certain limitation in granting of bail for offence involving commercial quantity under the Act. If one only, there are reasonable grounds to believe that the accused is not guilty of the offence with which he has been charged, and further that he is not likely to commit any offence while on bail. The discretion of enlarging bail can be extended in favor of the accused. So that is Lordship long incarceration and the decision of the apex court in so many cases, Lordship.
And for this 47 notice,
47 notice, no notice was sought to the accused and also his family members.
in the arrest memo,
It is their Lordship. I have phlegma, arrest memo, everything is their Lordship.
Atul, okay, I'll go. What is your submission?
2023 Lordship. And Lordship, regarding Lordship, 50 notice, I couldn't find that notice, but I found arrest memo, Lordship. I have phlegma. In arrest memo, everything was there, grounds of arrest was there, Lordship, and it was signed by the accused person, Lordship. And the arrest memo was specific to the petitioner's Lordship. They were caught red-handed, Lordship. Total, Lordship, 1,897.58 gram of heroin was recovered from them. Okay, petitioner number 2 was the driver, and the petitioner number 1 was the co-driver, Lordship.
Okay,
This page number 54 is the rejection order of the trial court over here. Point number 6, Lordship, it is clearly mentioned, Lordship. In arrest memo, everything was there.
heard Mr. L.R. Majumdar, learned counsel for the petitioner. Also heard Ms. M. Deka, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely petitioners, namely Sokohen, यहाँ पर नाम लिखिए, namely 1 and 2, who are detained behind the bars since 11/9/2023, within bracket for last 2 years, in connection with NDPS case number,
Lordship, it is 62,
62/24.
2020.
NDPS case number 62/2024, corresponding to Customs Department case number 01/CL/NDPS/PREV/SIL/2023-24, dated 10/9/2023, under section 21 within bracket C/29 of the NDPS. Learned counsel for the petitioner has petitioners has submitted that both the petitioners were arrested in connection with this case on 10/9/2023, and they are languishing behind the bars for last 2 years. He also submits that in this case, the trial court has been proceeding with the trial according to the procedure for trial of complaint cases instead of proceeding according to the procedure for sessions tribal cases. And accordingly, 5 witnesses were evident. The evidence of 5 witnesses have been recorded before framing of charges. He further submits that the charges were framed against the present petitioners on
1/9/2025.
1/9/2025. And now the case is pending for cross-examination of prosecution witnesses. He submits that the trial has not proceeded in an expeditious manner, and the petitioners are languishing behind the bars for more than 2 years, which has infringed the fundamental rights of the petitioner guaranteed to them under Article 21 of the Constitution of India. He also submits that in the instant case, no notice under Section 50/50A of the CRPC was furnished to the petitioners or their relatives slash friends slash nominated persons. However, the trial court had erroneously held while rejecting their prayer for bail on 15/5/2025 that no violation of Article 22(1) is there in this case, as the grounds of arrest have been mentioned in the arrest memo. The petitioner, the learned counsel for the petitioner submits that the petitioners are ready to cooperate in the trial, and therefore they may be allowed to go on bail. On the other hand, learned counsel for the Customs Department has vehemently opposed the grant of bail to the petitioners on the ground that the charges were framed in this case only on 1/9/2025, and the case is next fixed for cross-examinations of prosecution witnesses. And only 5 witnesses are there, and therefore the trial would not take much time to culminate. She also submits that in this case, the grounds of arrest were communicated to the petitioners at the time of their arrest by mentioning the same in the arrest memo, which were prepared at the time of the arrest of the petitioner. She, however, fairly submits that she could not find the notice under Section 50 or 50A of the CRPC in the case records. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the trial court records. Stop. I'll go through the records and pass the orders
All right.
in the chambers.
Lordship, I have small correction, Lordship. In the beginning, my name is recorded as additional, Lordship.
Yes, counsel for NCB. Counsel for Customs Department.
May I please lordships. So, my lord, 483 petition, my lord. In this case, my lord, initially, my lord, the father of the alleged victim girl, my lord, filed a complaint case, my lord, before the learned Chief Judicial Magistrate, my lord, Pokrajhar, and thereafter same was forwarded to the my lord, police station. And accordingly, the case has been registered. Initially, my lord, section 87 and 127 subsection 2, my lord. The case has been registered under section 87 and 127 subsection 2 of BNS, my lord. And my lord, subsequently, my lord, section 6 of POCSO has been added, my lord. So, my lord, kindly have a look at page, my lord.
Is pending investigation or
No, no,
trial?
charge sheeted, charge sheeted.
Charge sheeted, my lord, yes.
Victim has been examined.
No, madam, not yet.
Yes.
Last order I have flag mark, my lord, dated 18/6/25. It was fixed on 2/7/25 for copy. But subsequent, my lord, latest, today I have not checked, earlier I have checked, my lord. And
Total-
her 183, 183 as well as 183, my lord, I have checked.
Recorded.
What is your submission? What is the date of your arrest?
Date of placement 29/3/2025, my lord.
How,
Adjourned-
for how many days?
adjourned today, my lord, 158 days, my lord.
When charge sheet was submitted?
Charge sheet was submitted, my lord,
31/3.
31/3/2025, my lord.
After submission of charge sheet, have you moved bail application
Ye-
before the trial court?
Yes, my lord. That is at page 37, my lord.
What is your case?
Lord. Yes, my lord, actually, my lord, the petitioner is the, my lord, 22 years, my lord. And my lord, alleged victim girl was, my lord, studying in Jalabila Higher Secondary School, my lord. And my lord, there was some affairs developed in between them, my lord. And thereafter, my lord, on the previous day, my lord, on my lord 26/12/2024, my lord, she had gone to the maternal uncle's house of the victim, my lord. And thereafter on 27/12, my lord, 27/12/2024, my lord, she had voluntarily eloped with the, my lord, the present petitioner, my lord. And accordingly, my lord, actually, she suppressed her date of birth, my lord. She has told, my lord, to the petitioner that she has attained majority, then she will marry. But, my lord, when the petitioner, on the next day, my lord, when the petitioner and her family members came to learn that she has not attained the age of majority, and the petitioner's family member and the petitioner, my lord, informed the local VDP secretary, my lord. And thereafter, the present petitioner, along with his family members and VDP secretary and other villagers, my lord, handed over the victim girl to the, my lord, local outpost, police outpost, that is Shalkosa police outpost. And thereafter, from that police outpost, my lord, the victim girl was handed over to the parents of the victim girl, my lord, to her parents, my lord. And thereafter, my lord, the complaint case has been filed, my lord. And my case is that, my lord, as in recently, my lord.
Complaint case has been filed,
Yes, my lord, complaint case.
which was registered as FIR.
Yes, but subsequently registered as FIR on, my lord, on 2/1/2025, my lord. And same was registered on, my lord, 13/1/25, my lord.
We will continue after lunch.
My lord.
After lunch, we'll continue. Yes.
My lord, supplementary list item number 4950. It is under the admission heading. Two civil revision petitions, my lord. I have 2 minutes of submission, my lord. If it can be taken up today before rising or as per the convenience of the court. I am praying only for the stay of the proceeding which is pending in the trial court. And the matter had been heard by your lordship and further hearing was felt necessary, my lord. And the respondents are not appearing. So in ex parte hearing, my lord.
4:15, if it
Fine.
does not reaches. If
Fine.
it reach earlier, then otherwise 4:15.
Fine.
In this case, my lord, the petitioner actually was not arrested, my lord, but on asking by the police, my lord, he has voluntarily appeared, my lord, on 28/2025, my lord. And thereafter, on the next day, my lord, the accused petitioner was forwarded to the judicial custody, my lord. And thereafter, my lord, on 31/3/25, my lord, charge sheet has been submitted. But my lord, till date, my lord, no witness has been, even my lord, charge has not been framed, my lord. Charge has not been framed.
Yes, Mr. President.
And my lord, already, my lord, recently, some amicable settlement, my lord, has been took place in between the parties, my lord. And between the, my lord, guardians of the, my lord, petitioner and the.
Who is the informant?
Informant is the father.
Legal aid counsel for the respondent number 2.
Respondent, as well as earlier, no counsel appeared because of that legal aid counsel was appointed by this court. After completion of service, now he has appeared. And otherwise also now he, they have not perused the 183 statement. Now he stated that amicable settlement. Malad, may kindly see the page 37, the order of rejection. At that point of time, there is objection.
Thereafter, my lord. That's why, my lord, I have
Whether
submitted, my lord, recently, my lord.
compoundable, my lord, 16 years, 2 months. Her age is 16 years, 2 months, 183 and 183, both are almost similar.
No. Now, what is the objection in releasing him? That he may influence the witness, he may evade the process of the justice. So if he is ready to appear,
My lord,
you are apprehending that he may influence the witness.
yes. And he, Okalatnama by the mother, not by the victim. The victim statement is necessary. My lord, victim, that division bench also, Supreme Court also stated victim's hearing is necessary, my lord. Now, my lord, may see the statement of the victim girl, 180 and 183. 16 years, 2 girl, my lord, forcefully taken. She was not voluntarily went, my lord. She was forcefully
My lord, in
taken.
this regard, my lord, I have some little submission, my lord. Voluntarily, my lord. On the, my lord, previous day, my lord, she has gone to the maternal house of the petition victim, my lord. She has gone to the, my lord, it has been stated in the, my lord, FIR itself, my lord. FIR itself, my lord. On the previous day, she had gone to the maternal uncle house, my lord, of the victim. And on the next day, my lord, at evening hours, my lord, she had voluntarily, my lord, victim has voluntarily eloped with the petitioner, my lord, and directly gone to the house of the petitioner, my lord. And thereafter, when, my lord, initially, my lord, suppressed the age of the victim, my lord, she herself suppressed. She stated before the petitioner that she was studying at higher secondary. She has completed 18 years. But when the petitioner and the family members and other guardians came to know that she has not attained the age of majority, then, my lord, immediately they, along with the VDP secretary, my lord, is stated in the FIR itself, my lord. VDP secretary and other local persons, my lord, handed over the victim girl, my lord, to the nearest police outpost, my lord, that is Shalkusa police outpost. And thereafter, my lord, from that outpost, my lord. She was handed over to the guardian, my lord. And thereafter, my lord, the complaint case has been lost, my lord. Then how, my lord, she was forcefully taken, my lord?
My lord, may
It has, from the perusal of the FIR itself, my lord, it reveals that, my lord, no forceful, my lord. She was not forcefully taken out, my lord. She has voluntarily gone to the house of the, my lord, petitioner, my lord. Kindly see the FIR, my lord.
FIR is by mother. My lord, may peruse the statement of the girl, my lord. 180, 183 both. I have trademark.
Where is 183? In the case record.
Yes, case record, my lord.
Okay, what is your submission that as
My lord, she in 183 stated that earlier 7 months ago, she went, she was taken, and then also physical
now
relation.
charges are framed?
No, no, my lord.
No. Because
Yes.
in the
When is the date fixed for framing of charge?
no, my lord,
Not
up to
yet
that is
fixed.
not there. Because last order in the record is 18/6/25. It was fixed on 2/7/25 for copy.
What,
That is the last order. Up to
Now, the case is fixed for, my lord, production of accused.
if evidence then such maybe
Not
you,
appearance, my lord.
you pray before, what is your submission? Legal aid counsel.
Very premature stage, not even the victim was examined, and more so, lordship, the involvement of the petitioner father is also there. Though that sexual part is not there, but he was very much with his son. So that there is always a threat, etc. are always there because father is also involved.
Well, Chasi has not submitted against the father, my lord.
But
The same.
as per the complaint, etc., his father is also with the petitioner at that time.
Yes. What is your submission? Then why you filed the complaint? Let the victim be examined. You pray before the trial court after examination of the victim girl. I will issue direction for early examination.
My lord, will take much more time.
No,
Because, my lord,
we
that
will
is
fix the
the-
time frame.
Yes. My lord. My
Heard
lord.
Mr. S. Ahmed,
Shortly, my kindly-
learned counsel for the petitioner.
I'm sorry, my lord. One thing, as he has, for mother, he has appeared, my lord. He, for father, he may inform the client to, at an early date, he to go to and depose the statement of the victim girl, my lord.
Court,
If he has appeared and now stated that no objection, he may inform our client, his client.
but court has to fix the
My-
date.
Yes, ma'am. Yes.
Heard Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor, as well as Ms. B. Sharma, legal aid counsel, and Mr. H. Ahmed, H.A. Ahmed, learned counsel, learned engaged counsel for petitioner number, respondent number 2. This application under section 483 of BNSS has been filed by the petitioner Noor Jamal Sheikh, who has been detained behind the bars since 29/3/2025 in connection with special POCSO case number 34/2025 under section 87/127 within bracket 2 of BNS, read with section 6 of the POCSO Act, pending before the Court of London, Session Judge Kokrajhar. The gist of accusation in this case is that the mother of the victim girl had lodged a complaint before. Where is the complaint?
At page, my lord. Page 11, my lord. Page 11 onwards, my lord.
Lodged a complaint before the. No, 11 is the, where is the,
Yes, page 14, my lord. Page 14, relevant part.
complaint before learned Chief Judicial Magistrate Kokrajhar, inter alia alleging that the petitioner and his father namely Sajuddin Sheikh, have kidnapped the victim girl on 27/12/2024 when she went to the residence of her maternal uncle. The said complaint was forwarded by learned Chief Judicial Magistrate Kokrajhar to the officer in charge of Kokrajhar Police Station for registration of case and to conduct investigation. So after completion of investigation, charge sheet was laid against the present petitioner under the aforementioned provisions of law. Learned counsel for the petitioner has submitted that the petitioner was having a love affair with the victim girl and the victim eloped on her own along with him. So at that time, it is submitted by learned counsel for the petitioner that at that time, the petitioner was not knowing about the age of the victim girl. However, after it was known that the victim was minor at that point of time, the petitioner and her family members handed over the victim girl to the VDP secretary of the village for handing over same to her parents. Learned counsel for the petitioner has submitted that there is also a talk of amicable settlement going on between the parties and the trial has not yet commenced. And therefore, the petitioner submits that, and therefore learned counsel for the petitioner submits that as the petitioner is ready to cooperate in trial, he may be allowed to go on bail. On the other hand, learned additional public prosecutor as well as learned amicus curiae oppose the grant of bail to the petitioner at this stage. They have submitted that the victim girl in her statement recorded under section 180 as well as 183 of BNSS have implicated the petitioner in the offense alleged against him. And the victim was a minor when the alleged offense was committed against her. And therefore they submits that it would be proper to consider the application for bail only after examination of victim girl as prosecution witness by the trial court. They also submit that though the question of amicable settlement has been pleaded, however, the offense involved in this case are non-compoundable offense, and therefore the prayer for bail of the petitioner may be rejected at this stage. On the other hand, Mr. H.A. Ahmed, learned engaged counsel for respondent number 2, who is the informant of this case, has submitted that the informant does not have any objection if the petitioner is granted bail by this court. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the case record of special POCSO case number 34/2025, which was produced by, which was requisitioned in connection with this case. On perusal of the scanned copy of the statement of victim girl recorded under section 183 of the BNSS, it appears that she has implicated the petitioner of of having committed the offense alleged in this case. Therefore, this court is of considered opinion that before consideration of the prayer for bail of the present petitioner, the victim girl is required to be examined as prosecution witness in the pending trial against the present petitioner. Learned counsel for the petitioner has submitted that the next date of this case is fixed on 10-9 for what appearance? It is for
Production of accused. Production of accused.
the copies under section 207 has been furnished. You have received the,
Oh, my lord. As per instruction, it not been-
somebody submitted that it is fixed for copies.
but my instruction, my lord, copy has not been furnished. My lord.
Last order, which is available in the record, it shows that 18/6/25 is the order and 6/2/7/25 for copy. But subsequent to that.
Okay, learned counsel for the petitioner submits that next date is of the special POXO case number 34/2025 is fixed on
10-9.
10-9/2024-25 and copies of documents referred to in section 207 of the no, not 207. Copies of the relevant documents which were submitted along with the charge sheet are yet to be supplied to the petitioner and charges are yet to be framed. Considering the facts and circumstances of this case, this bail application is disposed of at this stage with an observation that with a direction to the trial court to expeditiously ensure the examination of the victim girl, with a direction to the trial court to ensure examination of the victim girl as early as possible. Preferably within 45 days of the date of this order. The petitioner shall be at liberty to approach the trial court after the victim girl is examined as prosecution witness to seek bail in this case. And in that event, the application for bail shall be considered by the trial court as per law. This bail application is accordingly disposed of. Send a copy of this order to the learned special judge Kokrajhar registry to send the copy of this order to special judge.
Obliged, my lord. One thing, my lord, this is special POXO case number 34/25, my lord.
25.
25. Somewhere. Obliged. Much obliged.
May please the lordship. Lordship, regular bail application lordship. I'm behind the bar since last 1.5 year lordship. I was arrested on 3/3/2024 lordship. Charge-sheeted case lordship. Charge sheet has been submitted under section 21C and 29 of NDPS Act lordship.
How many,
Lordship.
what is the exact time for which you are behind the bar? 1 year?
1 year, half months, 1 year, 6 months, 548 days lordship. Today,
They are on also.
548 days.
Their primary ground is
Grounds of arrest.
non-compliance of grounds of arrest.
Okay.
Grounds of
It is
arrest.
there or not?
No, lordship.
10 copy of the CD is not available. But
Lordship has already granted bail to the another co-accused lordship.
No, don't go to another co-accused immediately.
Quick.
First you put up your own case.
Yes, lordship. Grounds of arrest has not been mentioned, lordship, in the notice under section 50 and arrest memo also lordship. I have annexed both the copy lordship as annexer 8 and 7 lordship, page number 71 and 72 lordship. That is certified copy lordship. Page number 71 and 72 lordship. 71 is arrest memo lordship and page number 72 is lordship, notice under section 50 CRPC lordship. No grounds of arrest has been mentioned lordship.
Yes. Yes,
Certified
Mr.
copy lordship.
Sharma.
From the certified copy, it is clear, Lordship, it's not there.
Heard Mr. What is the name? T.
Thakuria
Thakuria.
lordship.
T. Thakuria, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely, what is the name?
Abidur Rahman, Mohammed Abidur Rahman.
Muhammad Abidur Rahman, who has been detained behind the bars since
3/3/2020.
3/3/2024, within bracket for more than 1 year, 6 months, bracket close, in connection with NDPS case numbers 272/2024, corresponding to STFPS case number 4/2024, under section 21C/29 of the NDPS Act. The gist of accusation in this case is quote paragraph number 3 from bail application number 1706/2025. Record होते आसे. From your custody, heroin was recovered.
No lordship. Actually, lordship, heroin was recovered from the other co-accused rented house. From the rented house of the other co-accused. That is Munnas Khan lordship. Was already granted bail lordship. That has been reflected in the charge sheet lordship.
Rented house does not belong to you.
Yes, lordship. Does not belong to me. Rented house does not belongs to me, lordship. Rented house belongs to Munnas Khan lordship. That has been
Quote
reflected.
paragraph number 4. Paragraph number 5. With duration to change koribo. Paragraph number 6, 7, 8. Your date of arrest is?
Date of arrest is 3/3/2024, lordship.
Date of arrest change koribo. Para 9, 10, 11, 12, 13. What was, how much was the contraband?
414 grams, lordship. 34 packets, lordship.
Heroin.
Heroin, lordship.
2 lakhs with 2 securities of like amount. With certain conditions. This bail application is accordingly disposed of.
Master bail.
31 and 32.
May it please your lordship. 31, my lord. 31, my lord.
For the start, Lordship, we could not go to the 10 copy, Lordship. Lordship, can it be on any other day? Lordship?
My lord, mine is, may I submit this petition before your lordship? It has come for quite some time, my lord, 2-3 times also. Now, more than that, my lord, in fact. This is, it's a regular bail application before your lordship. My lord, the petitioner is arrested on the 2nd.
What is your ground?
The ground, my lord, is that he was arrested in connection with GRP case number 4425 under section 20B to C29, my lord. May I take my lord to the FIR?
No, before that, we have to pass orders on his adjournment prayer. You are ready?
Tomorrow also, Lordship, we can do it. Lordship.
No, what are the grounds? On what ground you are?
My lord, the thing is, they have, it's a separate. 2 of them are there, mine is 11, and the other person, they have added it, saying, and then came up with a commercial.
Otherwise,
my
it would
lord.
have been
Lordship,
intermediate. quantity.
Lordship. That is,
And Lordship,
my
will
lord,
we be
it's-
permitted to go through this 10 copy and find out, Lordship, if there is any other materials which brings the criminal intention on ground, Lordship.
Okay, you go through.
Lordship.
We'll take it up after some time.
Lordship.
We'll take it up today itself. Let him go through this.
Lordship.
Their ground is
I understand.
simple ground.
Yes, I understand. Something to show that both were acting in the same.
Yes, yes. You go through it. We'll take it up after some.
Lordship.
33 is also same.
No, 31 is she is appearing, I am for 32. Both of us were arrested together.
In the same case.
In the same case, we were traveling together. That's the
Your ground is also same.
same, my lord, because we were traveling together, and that is the only thing which is because of which they have clubbed up. However, my lord, there are two separate seizure lists.
Yes.
My seizure list is different, her seizure list is different. My seizure list clearly shows it is 13 kg.
Okay, let him go through.
May please your lordship. My lord, in this case, the person is in custody since 27 December 24, my lord. About 9 months is in custody. And today is the court date calling for the scan copy.
There is an office note. Lordship.
Scan copy is not there.
Office note is there, Lordship. We could not go to the office note.
Which is the court?
My lord, it's supposed special at Kamrup Metro.
We will issue reminder.
My lord.
Fixing short date.
My lord,
POXO case. Is it a
it's-
POXO case?
Also, my lord. My lord,
Whether
the
notice has
allegation-
been served?
Allegation, my lord, is not an aggravated penetration assault, my lord.
Lordship will fix it
So
at
only
same date with
touch the
text.
private part, my lord. So the
No, but
Yeah.
notice has to be.
notice has also been served, my lord, 2 days before date. And married in custody since December 2024.
On the same day, Lordship will take the instruction, Lordship.
Now, my lord, as per FIR, my lord,
Heard Mr. A.R. Sigdal, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. It appears on perusal of the office note dated 28/2015 that scan copy of the trial court records have not yet been received. Issue reminder for the same. It also appears that the service report in respect of notices issued to respondent number 2 has also not been received. Learned additional public prosecutor is requested to get information regarding information about the fate of the notice issued to respondent number 2 from the officer in charge of the jurisdictional police station and let this court know about the same on the next date fixed. Let this case be
endeavor
listed.
shall be made to dispose of in the next.
Let this case be listed on 15/9/2023.
My lord, may I pray for an observation that matter may be disposed of from the.
No such observation.
My lord, this is the 2 days before date, my lord.
On that day, you may press.
My lord.
May I please your lordship? There is an application under section 483, your lordship.
Case diary is there.
Yes, 34, 35 and supply 51, 52. Same, my lord.
Date of arrest was 1/8/2025, your lordship. 33 days behind bar, your lordship. Maximum period, your lordship. 60 days, your lordship. I am manager of a bank, your lordship. Call your lordship Bandhan Bank. The FIR, your lordship, will get it at page 16.
What is the acquisition?
Accusation is, your lordship, is that this is in your lordship, some people, your lordship, the digitally arrested this
accused, the informant, your lordship, and from the him, your lordship, around 1 crore 70 lakhs 39,444. This amount of money has been transferred to your lordship various bank accounts. Your lordship,
From the informant.
from the informant. Your lordship. It was your lordship, he was, some people, your lordship, impersonating themselves as officers of ED, your lordship, digitally arrest him and then your lordship. force
What
him-
digitally arrest means?
That your lordship nowadays. is
Threatening.
Threatening.
That he will be
By
arrested.
calling in WhatsApp, your lordship, that then they will say that I am from CBI or ED from police and then your lordship force
They-
them. That has been done, your lordship. And this money was a portion of the money, your lordship, 28 lakhs rupees, your lordship. Out of this was transferred to an account, your lordship, in which I work, your lordship, as a manager, your lordship.
Transfer to an account of some person
Some person, your
whose
lordship,
account is there in your
in
bank.
my bank, your lordship.
Okay.
That's the allegation so far as I am concerned, your lordship. Your
How you
lordship-
are involved?
Your lordship, I am as such not involved, your lordship, but they say, your lordship, since I was there, your lordship, when a bank account was opened, your lordship, therefore they suspect my involvement, your lordship. Apart from that, your lordship, there is no material to show that this money has been transferred to my account.
Whose
Or-
account is this?
This, your lordship, they have mentioned it as, your lordship will kindly come to page 19. The grounds of arrest, your lordship, that has been, your lordship. This is a forwarding, not grounds of arrest. In the forwarding, your lordship, they have mentioned the grounds of arrest. So far as I am concerned, your lordship will kindly come to serial number 4. This account was, your lordship, of one Jalaluddin, your lordship,
No. Hafizur Rahman.
Hafizur Rahman. Your lordship will find at 4, your lordship. Again, after interrogation of Bandhan Bank manager Dipto Kumar Das, it was known that Dipto Kumar Das was searching a person who will deposit funding a huge amount of money to his branch, that he can take the credit of the efficient officer and seeking promotion from his higher authority. At that time, Javed offered a proposal to deposit a huge amount of money and accordingly they planned the same. Now, I have opened in under my, your lordship, when I was there as a branch manager, the bank account was open. Even if assuming it to be correct, your lordship, opening of a bank account cannot be an offense, your lordship, as such. But how money came to that, your lordship, who deposited it, that is not my business, your lordship. Ultimately, I can be held responsible if some portion of the money is transferred to either transferred to my account or some, your lordship, some recovery is made from me, your lordship. In both, it is not there, your lordship. And secondly, your lordship will kindly see, your lordship, that out of 1 crore 44 lakhs, your lordship, 28 lakh was deposited in Bandhan Bank, this particular account. Rest of the money is not in that account, your lordship. It has been transferred to various accounts that has been opened in different, your lordship, banks, your lordship. Other branch managers, etc., has not been, your lordship, arrested, your lordship, not even been interrogated, your lordship. Entire, your lordship, blame is sought to be on me, your lordship.
Whose account is this? Hafizur Rahman.
Hafizur Rahman, your lordship. He was also arrested, your lordship.
And how Jalaluddin is involved?
That, your lordship, only CD can reveal, your lordship. So far as I am concerned, your lordship, and
Yes.
secondly, your lordship, another aspect is there, your lordship. This is a, your lordship, these are sections, your lordship, in which, your lordship, maximum period of detention is 7 years, your lordship, up to 7 years. Now, they should have, your lordship, ideally, ought to have, your lordship, issued a notice under section 35, your lordship, 3, your lordship. That has not been complied with in the present case, your lordship. From, your lordship, Ernest Kumar to, your lordship, until, and then, your lordship, even Asfaq, your lordship, in all this judgment, Honorable Apex Court has clearly held that police will ought to have, or will have to have, your lordship, comply this particular section 41A for CRPC, or now, your lordship, 35(3). That has not been complied with, your lordship. Your lordship will kindly see the order rejecting my bail by the
Learned Trial Court, Your Lordship. That is at page 21, Your Lordship.
Yes,
Your Lordship will find, Your Lordship, at page 21. Page 22 onwards, Your Lordship, finding, Your Lordship, last paragraph of the page 22. I have perused the grounds of arrest enumerated in a forwarding report. IO has submitted that on the basis of the statement of the complainant, it came to light that he made a payment of rupees so and so to ED and he became victim of money fraud. After analysis of the bank details of complainant, it was found that on 31/1/2025, rupees 28,05,175 was credited to the Bandhan Bank account of Hafizur Rahman through RTGS. It is further submitted that during investigation, it is found that one person, namely Jalaluddin, offered that if Hafizur Rahman allowed to use his Bandhan Bank account to a person named so-and-so, he will deposit a huge amount of money in Hafizur account through Bandhan Bank branch manager, namely Deepak Kumar Das, and Hafizur should provide all the account related documents, ATM, etc. After interrogation of all the accused persons, sufficient materials found regarding their involvement in the commission of alleged offence. Further, IO has prayed for remand of all accused for 5 days. A ground of collection of evidence for arrest of the main accused person and for recovery of the money of the victim. Further, the IO has prayed for not allowing the accused persons to go on bail at this stage on the ground that sufficient evidence found of them. If the accused persons are released on bail, they will tamper with the evidences of the case and may hamper the investigation. Further, IO has submitted the ground for not serving notice under section 35(3) of BNSS upon the accused person on the ground that if they are given notice, then there is possibility of their escape from the arrest, Your Lordship. Can this such a casual statement can be basis of a, Your Lordship, reasoning for not complying with section 35(3) of Your Lordship, BNSS, Your Lordship? Casually they have said, Your Lordship. Can it be a basis, Your Lordship, for not complying with this? There will have to be something more to that, Your Lordship. That is not there, Your Lordship. And secondly, Your Lordship will kindly see, first of all, regarding the contention of the bail petitioner on behalf of the accused Deepak Kumar Das, it is seen that advocate contended that no notice under section 48 was served by the police. But going through the materials brought before this court by the IO, it appears that notice under section 48 BNSS was fulfilled by IO by serving the same upon one person, namely Mainul Haq, Your Lordship. I have made a specific averments here, Your Lordship, that I don't recognize this Mainul Haq, Your Lordship. Someone, Your Lordship, who has no connection, such casually, if Your Lordship, trial courts passes order, Your Lordship, then what about the compliance of these sections, Your Lordship? There's a complete disregard to the
yes.
complete disregard to the compliance of these particular provisions, both 35(3) as well as, Your Lordship, 48 of the BNSS. Even, Your Lordship, so far as 47 is concerned, Your Lordship, no copy of, Your Lordship, ground of arrest has been handed over to me, Your Lordship. I don't know, Your Lordship, whether they have taken any signature in any documents, but the fact remains that, Your Lordship, no grounds of arrest has been copy of the grounds of arrest which they required to submit it in, Your Lordship, to me, Your Lordship, furnished to me, Your Lordship. That has not been done in the instant case, Your Lordship. Above all, Your Lordship, in spite of all these violations, Your Lordship, I am behind bar for 34 days, Your Lordship. Probably, Your Lordship, further custodial detention is not at all required, Your Lordship. 60 days is the maximum period, Your Lordship. I have cooperated with the investigation, Your Lordship.
Yes.
Therefore, Your
Mr.
Lordship,
My lord, the Bandhan Bank, Deepak Kumar Das is the branch manager. And this Jalaluddin is the owner of the house where the bank is situated. my lord. Now there is a discussion between the manager, Deepak Kumar Das, and Jalaluddin, that if someone deposits a huge amount of money in my bank, there may be a possibility of my promotion if transaction is more in my branch. So would you provide your account? For that you get 4 or 5% extra money. Then Jalaluddin, he didn't give his account. He approached Hafizur. So assurance from the branch manager is that you will get 4 or 5%.
Percent of what?
of the money which will be deposited in the account.
But it is his own account,
No, it is-
Hafizul's account.
Subsequently, it will be taken by for that he has to.
No,
submit.
whether bank manager knew that
Malad,
the
yes.
source
exactly.
of money is illegal.
No, source of money not, but the money he has to deposit the ATM and all this he has to deposit. Now, Jalaluddin approached Hafizul, friend of Jalaluddin Hafizul. That you give your account and all the details, ATM and all this, you will get 4%. So 1% Jalaluddin will take. Then Hafizul give his account, ATM and all this, passbook and all this given to Jalaluddin, Jalaluddin given to Dipta Kumar. Subsequently, that 28 lakh something has been deposited by the informant. Now money was taken away withdrawn by Syed Javed, item 35. Money was taken back by someone. Javed, item number 35. So this is a malware and
No,
informant.
but whether the bank manager knew, is
bank
there
manager is
anything
statement.
to indicate that he
Yes,
knew
yes.
that the source of
Source.
would be illegal source? By threatening, sir.
When money was withdrawn on a single পিছত জাভেদে অনলাইন যোগে উঠাই লয় ঘটনাটো পিছত গম পাই মই ফ্ৰড হোৱা যেন লাগিল বাট অলপ সৰহকৈ টকা থব কাৰণে এজন মানুহৰ লগত বেংক একাউণ্ট লাগে যাৰ বিনিময়ত 4-5% একাউণ্টৰ গৰাকীক দিব আৰু একাউণ্টৰ গৰাকীয়ে একাউণ্টৰ সকলো তথ্য এটিএম চেক আদিবোৰ জাভেদক জমা দিব লাগিব দিস is the statement
Not me or
no from this is the statement of Dipta Kumar Das. He approached first Jalaluddin. So you provide your account. Where money, then this is the nexus, Malad. Otherwise, from the account of Malad, a person, Malad, stating to be the enforcement director personnel, they have siphoned Malad more than 1 crore. And in this present case, in the account of Hafizur Rahman, deposited more than 28 lakh. In a single account, and it was taken away by Javed. Online जुगे उठाई लय. And how Javed know? This was provided by the, because all the ATM and all this, as asked by Dipta Kumar Das, it was subsequently given to Javed. Account of Hafizur, talk with Jalaluddin, talk with him. He taken the ATM and all this, given to Dipta Kumar Das, subsequently given to Javed, and accordingly Javed withdrawn the amount, online withdrawal. So all were entangled,
Lordship,
and at this stage, only around 30 days,
32 days.
32 days. Investigation is going on because used for other, as per the FI, total money 1 crore 70 lakh 39,444. So others money has been deposited in other different banks, Eco Bank and all this. So investigation will go, at this stage, it's a very preliminary stage of investigation,
And what
And
is,
regarding 35, yes. Today also in one case, has gone through, when consideration was taken by the magistrate, it is not found proper that why not given 35(3), bail rejected, bail is allowed by the magistrate himself. Now here, in this present case, in the order itself, there is other petitioners, Dipta Kumar Das, Jalaluddin and Hafizur. That production order is of 2825, same order. 3%
whether checklist is there?
Checklist will be there, checklist. It is mentioned in the order. Seen the forwarding report, notices under section 47, 48 BNSS, arrest memos, inspection memos, and checklist under section 35(6) of BNSS produced before me. Now, last part of the order, Further, IO has submitted grounds for not serving notice under section 35 3 BNSS upon the accused persons on the ground that if they are given notices, then there are possibility of their escape from the arrest. So that consideration was taken by the.
On what basis he is
Your Lordship,
arriving
that
at?
is on what basis he has that finding.
My lord, prior to
He
that,
has to give reasons in writing that this is the basis of my satisfaction that he would escape the course of justice. Is there any material in the
my
case
lord,
diary?
I am reading.
Checklist
One
may-
checklist. Regarding that, regarding the not issuing of notice under section 35 3 BNSS, IO has submitted in the checklist that the arrest of the accused persons are
Yes,
necessary to
therefore you
prevent them
flag
from
mark the
committing.
checklist,
My lord,
flag the checklist,
my lord.
whether any reasons have been given in the checklist. Is
I
there
have
any?
given the checklist that the arrest of the accused persons are necessary to prevent them from committing further offences and to prevent such persons from causing the evidence of the offence to disappear or tampering with such evidence.
This is the
of the case.
conclusion arrived at
Yes.
by the IO.
By the.
There has
no,
to
no,
be
by the-
some,
No, by the magistrate, my lord.
no, magistrate is only narrating what
Yes.
IO has stated in his forwarding report.
Alright. I'll flag my checklist. my lord.
Okay,
Second,
I'll go through it.
secondly, your lordship will kindly note one thing, your lordship. Ultimately, your lordship, nothing has been recovered from me. That these bank account details, the ATMs, had those documents been recovered from me? If your lordship, any of the amount has been transferred to my bank account or anything, cash has been recovered from my house, your lordship, that is also not there. Simply, if I have even asked someone that you open an account here, you deposit a huge amount, and I will get promotion for that. How can that even be an offense, your lordship? That's the moot question, your lordship. And ultimately, your lordship, it is not me who has handled these ATM cards, etc. They have named someone else, your lordship.
Okay, heard,
Therefore, and your
heard
lordship,
Mr. S.
Ross.
Thakur, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Deepto Kumar Das, who has been detained behind the bars since 1/8/2025 in connection with Sapor PS case number 119/2025 under section 61 within bracket 2/318 within bracket 4/336 within bracket 3 of BNS 2023. The gist of accusation in this case is that on on 6/7/2025, one Nirmal Das had lodged an FIR before the officer in charge of Dhubri police station, inter alia, alleging that he has made payment of rupees 1,67,93,385 to the Enforcement Directorate on various dates beginning from 21/1/2025 to 9/5/2025 in pursuant to the message received by him on his received by him from Enforcement Directorate and also in pursuant to the video call conversations. It is also alleged in the FIR that the informant has made all the payments through offline and online to Enforcement Directorate. He has not stated why he made the payments.
Your lordship, he's a grade 4 employee, your lordship. This huge amount of money, your lordship. That's why
Who is Nirmal Das?
he is the informant, your lordship.
How he can make, why he has made these payments to E ED?
That aspect, they should have, your lordship, investigated, your lordship.
What the investigation says. Where is the forwarding of the petitioner?
Lordship will get it up, your lordship.
Learned
Page
counsel for the petition.
19.
Learned counsel for the petitioner has submitted that petitioner is the manager of the Bandhan Bank. Which branch?
Upper branch.
Of Sapar branch. And he was arrested on 1/8/2025. And at the time of his arrest, at the time of forwarding him before the magistrate after his arrest, the grounds of his arrest have been shown as that he being manager of the Bandhan Bank was searching for a person who will deposit huge amount of money in his bank so that he can take credit as an efficient officer and may get promotion from his higher authority. Learned counsel for the petitioner submits that the ground shown in the forwarding report for arresting the present petitioner does not constitute any offense, even if it is believed. Stop. He further submits that nothing was seized from the possession of the present petitioner. He only happens to be the manager of the bank in which one Hifzur Rahman opened an account, and in the said account there was huge transaction of money. Learned counsel for the petitioner submits that the petitioner is also seeking bail on the ground that the offenses involved in this case does not entail punishment of imprisonment for more than 7 years. Therefore, there was a requirement of issuing notice under section 35 within bracket 3 of BNSS before his arrest. However, learned counsel for the petition. However, in the instant case, no such notice was issued. Learned counsel for the petitioner submits that even if the notice is required to be dispensed with in such cases, in cases where arrest of an accused person is found necessary, the police officer effecting the arrest must arrive at a satisfaction that any of the condition mentioned in clause A to clause B, clause E of section 35 within bracket 1 within bracket 2 of the BNSS are there, and reasons for arriving at such satisfaction must be recorded in writing. 35(1) within bracket small b within bracket small 2 recorded in writing. However, in the instant case, his learned counsel for the petitioner submits that though the investigating officer has mentioned in the forwarding report that the reasons for dispensing with the notice under section 35(3) is that if such notice is given, there is every possibility of the petitioner escaping from the course of justice, however, no basis for arriving at such a conclusion has been stated in writing by the investigating officer. Hence, he submits that there is a violation of the statutory requirement of giving reasons in writing for dispensing with the notice under section 35(3). In this case, he submits that the requirement, the guidelines of the apex court has guidelines of the apex court given in the case of Anish Kumar versus State of Bihar, reported in, what is the citation? Reported in
2014 8 SCC 273.
has been violated in this case, and therefore on that count he is entitled to get bail in this case. Learned counsel for the petitioner has also submitted that the notice under section 48 was also not issued to the family members / friend or nominated person of the petitioner as is required under the statutory provision, said statutory provision. He submits that in this case, the notice has been issued to one Mainul Haq, who is not known to the petitioner, and therefore there is also a violation of section 48 of the BNSS in this case. He further submits that otherwise also nothing has been recovered from the possession of the present petitioner, and he is detained behind the bars for last 32 days, and considering the above mentioned aspects, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Sapor PS case number 119/.
47, signature of Dipta Kumar Das is there, 47 notice. Manul Haq was a witness. Manul Haq signature in the 47 also there as a witness. And in the 48 notice, here it is mentioned, signature of addressee, Manul Haq. Manul Haq signature.
No,
Manul Haq put his signature in the, as a witness in the 47 notice. As he put a signature as a witness, he may know the,
He may, how
No,
can may come? Your
is
lord?
there any endorsement in the case diary that why notice was issued to Moinul Haq? There must be some endorsement that for so and so reason, I'll go through it. Caliper. Learned additional public prosecutor has submitted that this is a case involving serious accusation and huge amount of money to the tune of rupees 1,67,93,383.80. And the investigation is still at very initial stage. He further submitted that there are incriminating materials against the petitioner regarding his complicity in the offense alleged in this case. He also submits that in this case, the grounds of arrest were communicated to the petitioner at the time of his arrest. And Section 48 notice was also issued to one Moinul Haq, who was the witness at the time of arrest of the petitioner. Learned additional public prosecutor has also submitted that the requirement.
The arrest memo also, Malad, name and address and email address of the person to whom convey the information of arrest. Here is also name is mentioned.
He also submits that now whether this name was furnished by the accused petitioner. No, there has to be some endorsement that this name has been furnished by so and so, therefore we are, or for some reasons must be there. He also submits that the arresting authority has complied with the requirement of Section 35 of the BNSS in clearly stating the reasons in writing which required the arrest of the petitioner in this case. He submits that as the investigation is at an early stage, release of the petitioner at this stage may hamper the course of investigation, and therefore he opposes the grant of bail to the petitioner. You give me the case diary. I'll go through the case diary and pass orders.
Deeply obliged.
Connected matters.
File.
Then date the again. Mr. Bhattakur, let me hear them. And if required, then I may not pass order today. I may take some time. Yes, 35.
Well, 35. Well, here how I am connected, my lord. Very strange, my lord, way. I don't know what is the case diary reveals, but as far as the forwarding report of there are two forwarding report, my lord, and the bail rejection order does not implicate anything against me, my lord. My lord, what happened, my lord? There are two parts in the case, my lord, which was not projected by the learned APP, my lord, in this case, my lord. What happened, my lord, in this case, my lord? One, Mr. my lord, Nirmal Das, he is the informant of this case, my lord. He has, his case is that he got some threatening call from various, on the behalf of, in WhatsApp, on behalf of some ED persons, my lord. And accordingly, my
No,
lord.
but there is no accusation of threat in the FIR.
Yes, yes. His part is that he has received some WhatsApp through WhatsApp. And
He has
according-
deposited money to ED.
ED.
On the
ED
basis,
account.
on the basis of messages
Yes.
and
Yes.
video calls.
Yes. So he has deposited as per their requirement. he has deposited the entire money, out of 1 crore or something in various banks, my lord. And one part of the money, that is this about 26 lakhs, he has made RTGS to one Hafizur Rahman of Bandhan Bank. So there's two parts, my lord. And now what happened in the Bandhan Bank is a different context, my lord, actually. It is no way connected, this is the first part, actually. This is a separate cause of action. How, my lord? Now, Lordship can see he deposited in the Hafizur Rahman, my lord. Now, these money, my lord. Now, I am Master, my lord, Javed. Now, who am I, my lord? The original, this bank, my lord, Bandhan Bank, the land belongs to me, my lord. Original. Then I have sold it to Mr. one Jalaluddin. Now, Jalaluddin becomes the owner and he is in contact with the manager. He is in contact with the manager, my lord.
Just,
Jalaluddin is the owner.
you are Javed.
I am Javed, my lord. I am absolutely no way connected, my lord. I'll definitely ask my lord, public prosecutor, my lord, where from he has made that statement, my lord. Lordship kindly see. Now, the Jalaluddin, he has introduced to me, my lord, to the bank manager and one Mr. Hafizur and Jalaluddin. And what they have suggested me to invest in that particular Bandhan Bank, so that the manager gets the promotion. If I invest the more money in the bank,
Deposit.
basically. So though the word is invest, as per their own word is invest, that's why I'm saying. They are saying that you invest the money in our bank and accordingly, so Hafizur, my lord, his account was used for that purpose, my lord. I have no connection with the Hafizur. Neither I have invested, not a single farthing, nor I have withdrawn a single farthing as far as my information, my lord. Simply, when they have, I was approached, my lord, I simply said, my lord, you have to talk with my CA, my lord. Then the CA was introduced to both of them. Then there is some talk with the CA. CA was also arrested. I don't know for what purpose, my lord, and he was released on the first day itself. His forwarding is also there. And my forwarding is also there, my lord. Lordship now kindly see, as far as my concern, my lord, I have not opened up any account in that particular bank. Neither I have withdrawn any money from that particular account, nor I have deposited any money in that particular account. No connection at all.
Where is your forwarding?
Lordship, kindly see the forwarding page, my lord. '27, my lord. The grounds of arrest, Lordship, kindly see. The complainant Nirmal Das stated.
Oh, what is this forwarding?
That is the forwarding, my lord.
Okay.
Type copy, my lord, page 27.
Yes.
The complainant Nirmal Das stated that he made payment of rupees so to rupees ED to ED to become the victim of money fraud. After analysis of the bank details of the complainant, it was found that on so 28 lakh some rupees has been credited to the Bandhan Bank account of Hafizur Rahman through RTGS from Nirmal Das. During the investigation, it was found that one person, Jalaluddin, after a proposal that if Hafizur Rahman allowed to use his Bandhan Bank account to a person, namely Javed, Javed will deposit a huge amount of money in the Hafizur account through Bandhan Bank. So that is in another context, my lord. That was the proposal, that I will also deposit account in the Hafizur account, and in lieu of that, Hafizur will get some percentage. So it is basically, my lord, to evade the taxes. It happens in some, my lord, it is the parking of the money. It's basically, if somebody wants to park his money to evade the taxes, they do it. This is the modus operandi.
Who is Nirmal Das?
Nirmal Das,
No,
informant.
what he does? What? He deposited such a huge amount of money. What his his statement has been recorded. You go through that statement. Yes, Mr. Bora.
Yes, my lord. Now, that's my lord, I am reading again. Javed will deposit a huge amount of money in the Hafizur account through Bandhan Bank branch manager, namely Dipta Kumar Das. And Hafizur should provide all the accounts related documents like ATM card, check, etc. Then Javed will provide 4% of the total capital as fare of his bank account. So that was the proposal was given to me as per their own statement that I should also invest, deposit account in the account of Hafizur. So
What account is this? Current account? Or savings bank account?
that I don't know, man. Because I have not deposited, I have no
Yes, Mr.
connected. man.
Parashar, you go through the case diary. What kind of account?
He's
is
simply
this?
saying he has not gone to the case diary properly, my lord. Now, where from he's saying,
I'm not saying so. I'm
my lord, that
I'm
every time
requesting,
making the query, he is absolutely silent. He's simply making the submissions. Where from? He doesn't know who is the informant, where he got all this money. He doesn't know it's a savings account or anything. Now, my lordship, kindly see what is my connection. Then the Javed will provide total 4% capital, whether I have deposited any amount in that particular account. After interrogation of the Jalaluddin, it was found that on October 24, the Bandhan Bank branch manager Dipta Kumar was offered a proposal that if he allows to use the Bandhan Bank account to a person named Javed, so it was to me, Javed will deposit a huge amount of money in the Jalaluddin's account through Bandhan Bank branch manager, namely Dipta Kumar Das. So I will deposit through the manager. So I am not directly connected. It was a proposal, and the Hafizur should provide all the account documents to ATM card, whether Hafizur has provided. Hafizur statement is there, my lord. Let him go through the Hafizur, whether the Hafizur knows me, whether the Hafizur has provided any ATM card, any checkbook to me, my lord. That will reveal, my lord, everything. Whether Hafizur knows me. Then the Javed will provide 5% total capital as a fare to his bank account, but the Jalaluddin will afraid to do, and rather he offered the same proposal to Hafizur Rahman and he convinced Hafizur to do that. So it was the Jalaluddin, the owner of the bank, my lord. He has, instead of him, my lord, because it was originally bank manager and the Jalaluddin, they have offered. But the Jalaluddin subsequently Hafizur. So Hafizur came into the picture, and the money has been, that money, the informant's money has gone into the Hafizur accounts, my lord. Probably it may be a case that the informant also parked his money in that particular account. That may be a case, my lord, to evade the taxes, my lord. It may not be ED, my lord. It may be a case, I have a strong apprehension, my lord. It is his money, he has deposited.
who's,
The informant's money, because this is the connivance, this is the modus operandi. Otherwise, a person, just because of the ED's name, he will transfer in the RTGS, making the RTGS in an unknown account in various parts, in 1 crore and something amount in the name of ED. And he has not lodged any complaint prior to the depositing, my lord. Now, lordship, next part is very important, number 4. Again, after interrogation, Bandhan Bank manager Dipta Kumar Das, it was known to that the Dipta Kumar Das searching a person who will deposit funding a huge amount of money to his branch, that he can take credit of the efficient officer and seeking promotion up from his higher authority. As that time Javed offered a proposal of deposit the huge amount of money, accordingly they planned the same. You are so-and-so accused Javed as did not confess his guilt, but he stated that there is a good relation between Javed and the manager Dipta Kumar Das because he is the owner of the bank premises earlier, my lord. From many days, manager Dipta Kumar Mas requested him to deposit a huge amount of money to his branch. So it was the manager has requested me to deposit amount, but I did not. Accordingly, on so and so, Javed agreed to do, but in certain condition that the Javed did not deposit the huge amount of money to his own Bandhanment account, rather than he'll hire an account of another people and he will pay 5% in the total deposit in the fair account. So they said that I'll not deposit in my account, rather I'll deposit to somebody else. That was the agreed, but it's not happened. And if that be so also, it's a case of, my lord, the siphoning the taxes, my lord, only. If I have deposited my amount, any of the amount in somebody else's account, my money, only to save taxes, that's a different context, my lord. This is not the case. You are arrested in connection to the case as maybe the take revenge on the complainant, victim, witnesses. Therefore, in the view of the safety of the security of the complainant, victim, witnesses, their families, friends, you are arrested. The sufficient evidence, so and so, so and so.
Yes.
Now, my lord, there is a bail objection also. Nowhere it has been stated that I have deposited any account, any amount in the Bandhan Bank, and my public prosecutor in the hearing of the other case, my lord, he has said that I have withdrawn the money. First of all, my specific that I have not an ingleness, my instruction, not a single farthing from that any of the account from the Bandhan Bank. Neither I know that this person, Hafizur, is there any connection whether the Hafizur has implicated me that he has given the ATM card, I have used the ATM card, or I have used the check, or anything, or ATM card. Absolutely nothing. Then the second part of my argument is that, my lord, here also, admittedly, the IO has stated the 35 is not been complied. Now, even the IO is completely silent in the forwarding why 35 was not complied. He was absolutely silent, man. Lordship has seen. This is a case of 7 years. Here, IO is absolutely silent why 35 was not complied with, man. And Lordship kindly goes through the checklist. In the checklist, Lordship will find simply whatever grounds has been stated in the forwarding, that has been just in replica in the case. No reasons has been assigned why my arrest was necessary and from where. They have come to conclusion. Any reasoning? There is absolutely no reasoning. The grounds of arrest are the same in the checklist, my lord. Now, here, there's in the checklist also, neither in the forwarding, there's in the remand order, Lordship kindly see, the learned magistrate from his own come to a conclusion, though there is no reason has been cited in the checklist, that I may evade the arrest. My lord, inner page 4. Certified copy of the inner page 4, my lord. Now, from the material on record, it appears that the accused person was arrested by the police from another district, whereas the targeted victim is a resident within the jurisdiction of this court. In such scenario, if the accused is served with a notice, then there was a chance of his absconding, and the same apprehension cannot be negated in the facts and circumstances of the present case. as the nature of the offence alleged is that can be committed from any place and time is a crucial factor in the taking of such kind of cases. Thus, in such a scenario where time is crucial, the issuance of notice might defeat the fair investigation process. Thus, in my opinion, it was just that on part of the police not serving notice under 35(3) BNSS, and hence the arrest of the accused person is justified. So his reason is, my lord, the reasons given by the IO in the checklist, it's nowhere it is mentioned that I may evade just because I belongs to a different district. How can just I belongs to a different district? How can that conclusion he can draw up, my lord? We are from the same state, from the same country. The Ernest Kumar does not differentiate any person who belongs to the same country, my lord. That if somebody resides outside the jurisdiction of that particular police station, he may notice may not be served. If I reside somewhere else, I may evade. That's not the proposition, my lord. That can be also. There cannot be any segregation, well, because of my residential address is different. And wherefrom he's come to conclusion, just because I am a different resident of different district, I'll evade the arrest. That reasoning nowhere in the checklist, my lord. Forwarding is absolutely silent that I will evade the arrest. Checklist is neither the IO has said I may be evade the arrest. The magistrate of his own come to conclusion that I may evade the arrest just because I belong to a different district. Can it be a reason, my lord? And where from? That can't be a reason, my lord. That's not the mandate of the Ernest Kumar, my lord, or until, my lord. You have to go at reasons has to be from some basic facts connected with the nexus with the case, my lord. There has to be. Just because I belong to some other district, then everywhere, my lord, there is no need for the arrest, notice, my lord, from the other district, my lord. Everybody were fled away in the other district. So that's the reason has been cited by the magistrate, only that, my lord. So where my learned friend will now say that whether I have withdrawn any amount or I have deposited or I have opened or I have deposited in the name of in the Hafizur account or Hafizur has given anything to me, my lord. Definitely Hafizur will say in his statement. Let
Yes,
him go to the Hafizur statement
Yes.
and where from he is saying that I have withdrawn money.
yes, Mr. Kurash.
There are certain allegations been made that I would go to the CD properly. I am not standing here to make bluff comment, my lord. Whatever in the material in the city, I am sitting before the court. Now directly come to the Hafizur statement, what he has stated. Should I make because before him, my lord, whatever. No, I am not asking the depositing before me, my lord. I am said the Hafizur must have introduced me. Yes, yes, I'm. If Hafizur has.
Let him submit.
I am not asking for your anything, you're from your side, madam. I'm just making the submission to the court that the, yes, I have also addressed to the court. No personal comments, madam. But the learned senior is making some allegations that I could not go to the city. Because you have failed to say who is the informant, how he has collected the money. That was the basic question moved by your lordship, my lord, not from me, my lord. Informant is a retired person of Indian Meteorological Department. Now, Hafizur statement, I am reading. October, November 2024 মোৰ বন্ধু জালালুদ্দিনে জনাই যে মোক বন্ধন বেংকৰ একাউণ্টত কোনো এজন লোকক টকা খবৰ দিব লাগে যাৰ বাবে মোক 4% টকা দিব সেই মৰ্মে মই বন্ধন বেংকৰ সকলো তথ্য পাতি ATM কাৰ্ড চেক আৰু বন্ধন বেংকৰ মেনেজাৰ দীপ্ত কুমাৰ দাসক জমা দিওঁ আৰু মেনেজাৰ দীপ্তৰ সকলো তথ্য পাতি জাভেদ নামৰ এজন ব্যক্তিকো দিয়ে তো মেনেজাৰ has given to জাভেদ also তথ্য পাতি
No, don't interrupt.
24 তারিখে মোৰ একাউণ্টত প্ৰায় 28,04,20 টকা সোমায় আৰু জাভেদে অনলাইন যোগে টকাখিনি উলিয়াই লৈ যায় on the basis of this statement I have stated before you, not making law. তাৰ বাবদ প্ৰায় 1,12,000 টকা মোক জাভেদে দিব বুলি কয় যদিও এতিয়ালৈকে দিয়া নাই জাভেদে দিব বুলি কয় যদিও এতিয়ালৈকে দিয়া নাই that is the statement of Hafiz. Hafiz's role is that my lord, he has given his for a
No, now this can be verified. From which account money has been deposited, to which account it has gone. Whether to that extent investigation has reached or not. From which account money was deposited. Yeah, okay. So your submission is that there is material to show that.
But that-
so online Hafiz, and that is the statement of all. Victor Kumar Malak, bank manager statement. Bank manager statement is Kishore Javede online দিকে টাকাটা উঠাই লয় মানে I'm reading two three lines of the from the Victor Kumar. Kishore 31/2024 তারিখে হাফিজুরের একাউন্টত 28,04,20 টাকা সোমায় SBI একাউন্টৰ পৰা সোমায় নিৰ্মল কাছাৰৰ একাউন্টৰ পৰা আহে পিছত জাভেদে টকাখিনি উঠাই লয় গোটেই ঘটনাটো মই পিছতহে গম পাওঁ ফ্ৰড হোৱা যেন লাগিল so জাভেদে টকাটো উঠালে that is the statement of the bank manager also.
How it was done? How the money was transferred?
Money only done.
The account holder has to transfer it. Hafizur's.
Check, passbook, all given to ultimately the bank manager.
Therefore, this has to be verified by which mode the money was transferred.
This all citizens to like
Okay. And regarding,
But that-
so I'll come to you.
Hello.
So your submission is that there is evidence in the case diary to show that Javed had withdrawn the amount. And
47, 48, arrest memo, all are there.
35(3),
That's payment made way and
okay.
that is as per the and that learned administrator mentioned that as per the statement of the IO as recorded.
Your flag mark,
Well, first of all, my lord, if he has completed one. First of all, I have not said, my lord, I said where from. I'm not saying that he's bluffing. I'm saying that is there any specific material to show that I have deposited? Because if I have withdrawn the money, it is the money has to be from the informant's money. Because I have not given any account. As far as the first forwarding report, it was agreed that I'll deposit money, but I have not deposited money as per the forwarding report. In the forwarding report, there is no whisper that I have withdrawn the money. In the checklist, there is no whisper that I have withdrawn the money or I have deposited. Had it been that I have deposited money in the Hafizur account and subsequently Hafizur has given it all the document or whatever to me through the bank account, then I have withdrawn subsequently through Hafizur or somebody else, because Hafizur has to pay back to me, or I have to fraudulently withdraw it. It has to be from my money, first of all, because it was the agreed upon that I have to deposit in a particular account, in the Hafizur's account, and I said, yes, I'll deposit, but subsequently there is no deposit in the Hafizur's account. The money only came to that Hafizur's accounts from the Nirmal Das, not from me. It was Nirmal Das money. So why Nirmal Das money I will withdraw? I can't withdraw.
there cannot be two parts, my lord, in the prosecution case. One part they are saying that the Nirmal Das, out of the threat or whatever, he has deposited in the name of in the Hafizur account. And the subsequently bank manager also wanted me to invest or deposit in that particular account. So accordingly, it was agreed through my CA that they will also arrange one account to deposit my amount. But I have not deposited any amount. If I have not deposited my amount, where is the question of taking the Nirmal Das amount, money? It is Nirmal Das money. Why they have allowed? They can't be, my lord.
Okay.
So that is the one part. So my contention is that and these are the documentary evidence, my lord. Only the Hafizur say, if the Hafizur statement through his statement will not do, because all the transaction has happened, it has to be through the document, my lord, online payment, and it has to be their material in the case diary, that the every money, it has been withdrawn by me to my account or somewhere. That has to be in the case diary. Why? The initially, my lord, in the forwarding and the checklist, there's not a whisper that I have withdrawn the money. Somebody is withdrawing. That is a different issue. Then the next point is that there is nothing that the IO has given any statement before the magistrate regarding my abscondence, my lord. It was by the
Yes,
magistrate's own.
that you have submitted.
Yes. My lord, he has submitted that it is on the basis of the IO statement,
Okay.
magistrate has said. It's not that correct, my lord. The magistrate found the materials on record. It appears that accused person is arrested from the another district. So whether that is the sufficient reason as per the lordship own judgment, recent judgment, that is not sufficient, my lord.
Mr. A.M. Bora, Learned Senior Counsel assisted by Mr. V.H. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Syed Javed bin Zia, alias Javed, who has been detained behind the bars since 3/8/2025 in connection with Sapor PS case number 119/2025 under section 61 within bracket 2/318 within bracket 3 of BNS. Gist of accusation, Agor Kestur Parliament. Learned Senior Counsel for the petitioner has submitted that the petitioner was arrested on 3/8/2025, and at the time of forwarding him, at the time of producing him before the Learned Chief Judicial Magistrate, Learned Judicial Magistrate Bilasipara, in the forwarding report, it has been stated that the petitioner was having a good relationship with the co-accused Dipto Kumar Das, who was the bank manager of the Bandhan Bank Sapor branch, and it is also alleged that the petitioner agreed to deposit huge amount of money in an account which may be hired, in an account of some other person which may be hired for the purpose, and for this said purpose he would pay 5% of his total deposit as fare for the account. It is also alleged in the forwarding report that no, stop. Learned Senior Counsel for the petitioner submits that the petitioners is not involved in the offense alleged in the FIR in any manner. He submits that in the FIR, there is specific mention about deposit of money by the informant only by the informant, namely Nirmal Das, in an account in the name of
Hafizur Rahman.
Enforcement Directorate. In the name of Enforcement Directorate on various dates. He submits that there is no accusation leveled against the petitioner in the FIR by the informant. Stop. Learned Senior Counsel further submits that the petitioner does not know any you do not know Hafizur Rahman,
My lord.
does not know any person by the name of Hafizur Rahman, and he does not have any relationship with the said person. He also submits that petitioner has not withdrawn even a single penny from the Bandhan Bank from the account of said Hafizur Rahman. Stop. He further submits that in the instant case, though the investigating officer has not issued notice under section 35 within bracket 3 of the BNSS before arresting him in this case, neither nor any reasons for arriving at the satisfaction regarding existence of any ground mentioned in clause A to E of the section 35 within bracket 1 within bracket small b within bracket 2 of BNSS has been stated in writing by the investigating officer. He submits that investigating officer has only stated that where is the 35 the
In the forwarding, there is nothing, my lord. He has not given any reasons for that, my lord.
35(3) has not been mentioned.
No mention, my lord.
He has not mentioned anything in the forwarding report to the learned judicial magistrate first class regarding dispensing, regarding the reasons why notice under section 35(3), 35 within bracket 3 of the BNSS has been dispensed with. He further submits that, learned senior counsel submits that, however, in the instant case, learned judicial magistrate first class, Dhubri, Sapor, Bilasipara, in the remand order dated
3/8 to 2025. 3/8.
remand order dated 3/8/2025 has himself arrived at a conclusion that as the petitioner hails from a different district, there was a chance of absconding and there was a chance of his absconding.
And only apprehension cannot be negated, he said. Not on based on facts, only on
And the
apprehension.
said apprehension cannot be negated. However, learned counsel for the petitioners, learned senior counsel for the petitioner submits that no such reasons were mentioned by the investigating officer for dispensing with the notice under section 35(3) of BNSS. He further submits that it is for the arresting authority to justify in writing why the notice under section 35(3) is dispensed with. And the magistrate is only to verify the correctness of the reasons shown by the investigating officer. However, in the instant case, without there being any reasons in writing shown by the magistrate, by the investigating officer, the magistrate on his own arrived at a conclusion, which is in accordance with, which is according to learned senior counsel, is beyond the scheme of section 35 of the BNSS. He further submits that the petitioner has been detained behind the bars since when?
32 days, my lord.
For last 33 days. And considering the period of detention, as well as the fact that he is ready to cooperate in the investigation, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has vehemently opposed the grant of bail to the petitioner at this stage. He submits that there are sufficient incriminating materials against the petitioner in the case diary. He submits that in the statement of the co-accused recorded under section 180 of BNSS, they have categorically implicated the petitioner of having deposited huge amount of money, having withdrawn the money deposited by whom? Okay, withdrawn huge amount of money from the account of Hafizur Rahman. Here, by online transaction. He further submits that the arresting authority has complied with the requirement of procedural requirement of furnishing notice under section 47/48 in this case. He also submits that in the checklist prepared under section 35 within bracket 6 of the BNSS, reasons have been mentioned which necessitated the arrest of the petitioner in this case. Stop. He also submits that the investigating officer has justified the non-issuance of notice under section 35(3) by stating that in event of issuance of such notice, there was a possibility of the petitioner escaping from the course of justice. Learned additional public prosecutor therefore submits that considering the early stage of investigation and huge amount of money involved in this case, the prayer for bail may be rejected at this stage. I have considered the submissions made by learned counsel for both sides and have gone through the case. You flag mark the case diary. And right there, which is for Javed, which You are relying for Dipto.
My only one more submission, madam. This is basically based on the documentary evidence, as I said. So co-accused statement before the police is not the sufficient material, madam. It has to come up from during the investigation that, yes, the money was withdrawn by me through RTGS or through by other modes. Whether that material
Learned
is there.
Senior Counsel
And
also submits that there is no material on record which suggests that the petitioner has withdrawn any money from the account of Hafizur Rahman.
and as because there is no whisper in the forwarding
Stop.
of the
He also submits that in the forwarding report of the investigating officer at the time of his production before the learned Judicial Magistrate First Class Bilasipara, no whisper has been made regarding the fact that he has withdrawn any amount of money from the account of Hafizur Rahman.
or any document has been submitted to him.
Or,
Details.
or that any document like PAN card, the ATM card, and that any ATM card of Hafizur Rahman,
And nothing was seized from me. ATM or PAN card.
ATM card or PAN card or any other document has been seized from. Itu senior counselor argument jab.
Right.
I'll reserve the
But-
order. One more item is there.
He has taken much time, my lord. And ultimately, light also didn't allow him to.
Huh?
continue. Yeah. Light
Komal,
also-
apni থাকিব লাগিব।
We are the small fry, my lord. In between branch manager,
Who are you?
I am the Jalal and Hafizur.
You are the main person.
No, my lord, nothing, no. What is your lord, kindly say, what is the section involved in the case? Section cheating, forgery. Jalaluddin, nothing, but he is simply having a bank account in the.
Who is monitoring this investigation? Who is investigating who is the investigating officer? ED? Designation is additional SP. What does CDSP means?
Core districts SP.
Co-district.
Core district SP.
Now,
Because Bilashpura is,
now,
it is core district.
Okay,
So SP ultimately SP level.
okay, now what is this is item number?
51 and 52.
We
51 and
will
Hafizur,
take one by one.
yes.
Hafizur, what
51
is your
and Hafizur.
submission?
So Hafizur, madam, my only question, my your lordship, can we see what are the sections alleged and what the offense we have committed, my. Cheating, forgery, criminal conspiracy, madam. Allegation against the petitioner in the FIR, nothing. Only we find in the FIR, your lordship will find one deposit, page 15, your lordship, can be seen. Page 1. Sorry. Page. Here, page 2. Yes, page 15.
Yes,
One amount, madam, that is 12, serial number 12. 28 lakhs 4,620 that was deposited in the account of Hafizur.
oh, this was the report.
Yes, this, yes. So he is
These all
account holder.
three, all four cases are in respect of this account, this amount only.
Yes.
28. Bandhan Bank
No,
Safar
no,
branch.
one crore 67.
No, that is the
Oh, yes.
total
Oh,
involvement.
total. Yes. So 28 lakhs, madam. 28 lakhs.
Is the account holder. He given the.
Yes, I am having account there, my lord. In that bank. So depositing is neither it comes as cheating, nor it is forgery, nor it is a criminal conspiracy. madam. Where are the criminal elements, madam? What they have done? What offense they have committed?
This is your account.
Simple, madam. I am not taking much time because I have no other involvement at all, madam. It is my money. I have deposited money. I have neither taken any money from anybody else, nor drawn any money.
No, but the accusation is that Nirmal Das has deposited this
Yes.
money to your account.
No, I am having my account in the Bandhan Bank. madam.
Yes,
Maldas model once only next item will also come. He told Jalal Maira that I need one account more to be open in order to get my promotion. If I
no, that is by,
Jalal,
that is by manager,
No.
bank manager.
bank manager told Jalal Maira,
Yes,
Jalal.
but the money has been deposited
So
in your
Jalal
account
Maira
by,
ultimately Hafizu opened the account. The new account which was supposed to be opened for the purpose of promotion of manager Maira. Hafizul came and he opened the account. Earlier also he was having account there in that bank also. Maira. So he had deposited money in his own account.
no. The
Yes.
accusation is
Uh,
the money has been deposited to your account by Nirmal Das,
My lord.
by Nirmal Das, the informant.
So Nirmal Das might have done, my lord. What I am having account in the Bandhan Bank. I am having account in the Bandhan Bank. This money, Jalaluddin account and his account earlier, item 52. His account is there and Hafizul account subsequent to my lord, because that part I cannot say. But so far this FIR is concerned, serial number 12, that is that they have shown the 28 lakhs deposited in my account. So whether I have taken any money from anybody, my lord, that you lost you to see, my lord. Actually, the person, my lord, Nirmal Das, that is the informant, actually he is to be taken to task, my lord. Where from he got the money? And what he did, my lord? Where from it came, my money? And he is in all the person, my lord, because of his complaint, everybody is master, bank manager, other person, all persons are being roped, my lord, and they are in custody, my lord. What offense, criminal offense they have committed, my lord? I am only on that, my.
No, the FIR is not very,
If I
Yes.
simple, nothing.
it
no
is
whisper
not in
against them.
detail.
Only
but it gives an
my lord. A
indication.
person simply got a message from WhatsApp and he had deposited money, my lord. Is it believable? He is the person, my lord. If he is to be inquired properly, everything will come out, my lord. This informant, my lord. Simply WhatsApp message, he has deposited so much of money.
What Nirmal Das has stated,
My lord,
has he been
he-
threatened?
He was given some photograph messages and all this. Actually, these are fake affair. Some fake affair registered at Maharashtra that has been given to him. That
And
the-
in
the
lieu of
ED
that, he was asked to
ED case,
deposit money.
ED case has
But
been registered.
inquiry report will make it very clear, my lord. Inquiry.
These materials are also in the.
In the case diary, it is there.
It is here, my lord. Some Mumbai Police Department, 10 most wanted, where police personnel is also involved. It was shown, photograph has been given, that a big case, big scam has been.
And he was
involved.
given different account numbers to deposit the money,
Yes.
This Nirmal Das.
Nirmal Das.
It was given.
Therefore, the suspicion on the,
No, he was told, Nirmal Das was told that any money he come to the account, it has to be go our verification. So, my lord, he has given in different account, he has deposited money. And they have told that after verification, we will return your money. But subsequent.
Madam, only
All are
page
report.
18, madam. Just inquiry report, only one page, madam. Page 18, madam. Page 18.
yes.
Last, madam, during inquiry, visited SBI Chapor branch, you also got him. And talked to the branch manager. The branch manager told that the complainant Nirmal Das came to the bank 6-7 months ago. And he wanted to transfer funds to some other account. And the complainant would draw all the FD fixed deposit before the maturity. Since the quantity of the money was huge the branch manager awarded the complainant of cyber crime. Branch manager is making him, my lord, that is warning, and denied to transfer the funds without proper justification. But the complainant, namely Nirmal Das, complained to higher authorities of bank that the branch manager is denying to transfer funds. Accordingly, on the instruction of higher authorities, the branch manager transferred all the funds via RTGS to the designated account. Besides, Nirmal Das went to UCO Bank, Chapor branch, withdraw all his money and transferred to the designated account through RTGS. Nirmal Das denied to disclose anything to the bank employee, as he was threatened by the miscreant that he would be taken into judicial custody if discloses anything to anyone. Then you will kindly see, madam. Further, it is found that the money from the UCO Bank is transferred to the account in the name of Petal Enterprise, holding account in Bandhan Bank. Subsequently, I inquired in Bandhan Bank and found that the account has been created by one Arvind Patel in Bhopal branch, Ahmedabad, mobile number so and so. Further, it is found that the complainant is maliciously manipulated and threatened by the miscreants and fraudulently manipulated Nirmal Das to transfer funds from his account to their account. The complainant still believes that the ED has taken his money. Complainant still believes that ED has taken his money. It is to be noted that the ED and the FIR of the instant case are falls apart in body. So this is the case, man. Completely different aspect, my lord. It's cyber crime. And these innocent persons are being brought in mind.
My lord, regarding the
Now, what else is your submission?
So-
Your submission is that the money belongs to you,
Which one?
this 28,
No, 28 lakhs matter. I did not say in my account it was deposited.
and who withdrew it?
Not, I have not withdrawn. I do not know who withdrawn mine.
Okay.
I don't. My account is closed. my lord.
The account is closed now.
Yes. All account, I think all account.
Closed or freezed?
I do not know, my lord, but he is in custody, my lord, so we cannot say, but we have been told that, my lord, it is now closed.
Okay, your case is of simple denial.
Simple denial and criminal offense is not at all there, and 35 is also, my lord, as your 30, section 35 is not complied. Agnes Kumar and Antil, my lord. Chaitanya Antil, my lord. That also you always kindly note, my lord. 2022-10 SCC.
Okay. Yes.
my lord, that I don't know, 51, yes, Hafizur, though his account, but his account name is Aryan Store. He has a store, Aryan Store. So the account number is there. Account person is Hafizur Rahman, but the name of the account is Aryan Store. I have flag mark the check how by RTGS 28 lakh 4,667 was deposited by Nirmal Das in the account of yes, Hafizur Rahman, that Aryan Store on 31/1/2025.
And withdrawal,
Regarding withdrawn part.
there must be something.
Withdrawal part we are not there. The
Okay.
next item was same, my lord.
Withdrawal part,
Aladdin, of course, no money, no transaction, nothing.
Or Mr. H.R.H. Chaudhary, learned senior counsel, assisted by Mr. A. Hussain.
Permits one thing, I
Yes,
want to add,
Yes.
as my learned friend has said, that this his account, and he has, it was the stop, he has not said that it was given to me, man. The allegation is that as per his statement, my lord, in the case diary, that he has given everything to me, but he has said he was not given anything to me. It settles the proposition that
I am not blaming anybody, my lord.
that means, my lord, we are not
Oh,
connected.
oh, Okay, I'll go through.
My lord, he is
That-
taking chance, my lord. Yes, but I am not blaming him.
His
Yes,
statement,
yes,
that is,
yes.
I'm just putting it on record.
I'll go-
Continue my statement.
I'll go through the case.
Yes,
study.
Yes.
And the lordship can see that from the inquiry report, which is just now I got it, my lord. The second paragraph is something very, very
Oh, this is-
serious, my lord. It is basically the Nirmal Das.
Ah,
Lordship can see he is the person.
so-
He has, my lord, the lordship can see, he did
No,
the
no.
inquiry.
Mr. Bora,
Well, I have already stated, my lord.
the accusation is Nirmal Das collected all his life earnings. And
He wanted,
to
but
the
he's withdrawn, my lord.
he has not
No,
withdrawn.
Lordship kindly see.
Yes,
He has withdrawn the fixed deposit
Yes.
to deposit
He
it
wanted the bank manager to give it into different accounts. my lord.
designated account.
Yes,
Those designated accounts were given to him by the phone caller
yes.
that you,
So that's
and
what
one
I-
of the designated account is of Hafizur Rahman.
So, the designated column, I am having account in the bank.
You may not be knowing,
No,
So
Lordship kindly
that may
see.
be there, so.
but that is the accusation.
My lordship can in the, because of the bank manager did it, he was initially refused to transfer the all money, man. Lordship kindly see.
Yes.
Yes,
And he has did it because of the some external pressure subsequently. That is the, in the report. Initially, bank manager, he has not allowed because money was very huge. So that's the said, but the complainant, namely Nirmal Das, complained the higher authorities of the bank that the bank manager is denying to transfer the funds. That means he initially he denied. That means bank manager is not involved in this case. He has denied. He was not in consort with the debt. Then thereafter, my lord,
okay, I'll go through.
instruction of the higher authorities, bank managers transferred all the funds to RTGS to the designated account.
I'll go through it. क्या लिखा? Assisted by Mr. A. Hussain, Learned Counsel for the petitioner. This application itu likhibo yako na. Learned Senior Counsel for the petitioner has submitted that though the petitioner is having an account in the Bandhan Bank Sapor branch. However, he had not deposited the amount of rupees 28 lakhs 4,620. Neither he has withdrawn the said account from his. If you have not withdrawn,
I have neither deposited nor withdrawn.
how money was transferred without your consent?
This is the problem. Who did it, my lord? That is to be inquired. my lord. So far I am concerned, I have neither deposited, this money has come to my account.
Okay.
It is their part, they have to say, my lord.
Okay.
Who withdrawn the
Then
money and
I
who
will go
deposited
through
the
the
money.
case diary. Neither he has withdrawn the said amount. Learned Senior Counsel for the petitioner submits that the offense alleged in the FIR has not been made out. Any of the offense alleged in the FIR has not been made out against the present petitioner. He also submits that though the offense alleged in the FIR entails punishment not more than 7 years, no notice under section 35 within bracket 3 of BNSS was served on him. And the guidelines issued by the Apex Court in the case of Arnesh Kumar versus State of
And also
Bihar.
come on until.
as well as Satandar Kumar Until versus CBI has not been followed in this case. And therefore, the petitioner is entitled to get bail on that count. He further submits that the petitioner is ready to cooperate in the investigation. And considering the period of detention, he may be allowed to go on bail.
3 days, my lord, today.
On the other hand, learned additional public prosecutor has produced the case diary of Sapor PS case number 119/2025 and has vehemently opposed the grant of bail to the petitioner at this stage on the ground that there are sufficient incriminating materials in the case diary against the present petitioner.
He did not say, my lord, sufficient material against him.
You say it now.
How he will say, my lord?
He has indirectly stated. The he also submits that the procedural requirement as mandated under section 35 of the BNSS has also been complied with in this case, as reasons for arresting the petitioner has been stated in writing in the checklist submitted under section 36, 35 within bracket 6 of the BNSS, as well as in the forwarding report. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. In next case, what is your submission?
Nothing against him, mother. Only mother, branch manager requested him to bring one customer, madam. That much he made a request, I did not comply.
Next,
Yeah,
He did not, as asked by bank manager,
yes, I did not.
his account, but he asked Hidu,
Jalaluddin. How Jalaluddin is involved?
He's having
now
bank,
house owner. He is the house owner, the bank is on rent. Then bank manager asks, requested Jalaluddin whether he can give his account, whether in that account, some money will be deposited and 5% he will get. Then he didn't give his account. He requested Hafizur. Hafizur give his account and all details ATM cards are given. And Jalaluddin said that he will give 4%. Meaning, between he will take 1%.
mother,
No,
paragraph
no.
5.
He took Jalaluddin.
The prosecution's case is, I do not know what is the stage of investigation, but contrary. At one stage, you are saying that Nirmal Das was told by an unknown caller where to deposit and what amount. The caller told him that where to deposit what amount. And on the other side, you are saying that so these people may also be caller. Okay,
But that has not come, my lord.
okay.
Anyway, Jalaluddin, I think, mother, nothing is over. And only one section, my lord, section 62 of BNSS. Mother, that about this 35, just, my lord, your lordship, no arrest shall be made. Except in
62.
62. Except in accordance with that 35, etc. That,
Okay.
that is.
In last item, that is item number
Paragraph 5, I
52.
have stated my,
Baki Eke Nisnal Likhibo. Learned Senior Counsel for the petitioner has submitted that the present petitioner is in no way involved in the offence alleged in the FIR. The only accusation against him is that he introduced Hafizur to the branch manager on his request to identify some customer
for his
who-
books.
who may deposit huge amount in his bank so that he may get promotion. Regarding 35(3), same submission.
Same. 62 also same, man.
Okay.
Section 62.
Yes, Sarita. You, Mr. Parashar, you go through the case diary carefully and then mark there.
Only five, my lord, only page 19, just have a look at page 19 of item 52. Man. Page 19 of item 52.
Item 52. On 9.
19. The reasons for police remand. For collection of more evidence and witness. For arrest of main accused, namely Javed, since from the interrogation of all the accused, it is clear that the main mastermind of this offense is Shah. So he has already been arrested now.
Okay.
That was already arrested, my lord. So further custody, I am only on that matter, only 33 days over these two petitions.
Release this matter for delivery of orders on 9th of September, Tuesday.
Ninth.
Tuesday.
By that time, it will be about my lord, nearing 40 days.
You may get benefit of those days.
Obvious. And
Have
if you
to-
was, and all documentary evidence, my lord, nothing remains so far, this thing is.
Updated, I think 49 and 50.
Yes, miss.
31 that the council is to see to go through the record and then that the matter will be taken up. Item 31 and 32. my lord.
Who is going through?
But I understand also, my lord, that you have fixed one at 4:15. It's a simple one, my lord. The ground is that two persons.
You
were
have gone
traveling.
through it. No, let the matter which has been called. You will take how much time, Mr. Shah? Yes. Mr. Singh. 3 minutes. Wait for 3 minutes. You have to wait.
My lord, why this matter was mentioned, I am praying for staying the proceeding of the learned trial court since the matter was heard. Further hearing was felt necessary, my lord, by the honorable court. So I'm ready on any date. If the matter is fixed, I will address the final argument. But in the meanwhile, since the matter is proceeding.
Who is for
because
the
it-
other side?
No one is appearing, my lord. And
Heard Mr. S.K. Singh, learned senior counsel assisted by Mr.
A. Ganguly.
A. Ganguly, learned counsel for the petitioner. Learned counsel for the petitioner submits that both these civil division petitions, both the above mentioned civil division petition are heard in part and it has been substantially heard. However, in the trial court, as
The absence of any stream.
however, he submits that in view of the pendency of this civil division petition, the further trial of the further proceeding of the which cases?
Title suit number 11/10, my lord, and 19/11.
They are pursuing the matter in trial court
Of late, they are not pursuing there, my lord. I don't know.
because they have not appeared in this case.
Yes, but they are keeping an eye, my lord. On every date we visit, they remain present. But we are only informing that the matter has been part heard. And very soon we can expect the final result. But initially I did not. pray for
Title suit number
11/10, my lord,
11/10
and 19/11.
and 19/11.
Both pending
19/11 pending before the Court of Learned
civil judge, junior division,
Civil Judge Junior Division,
Lakhimpur.
Lakhimpur are required to be stayed in view of the pendency of this civil division, these civil division petitions. Stop. As the above noted civil division petitions are already heard in part, there is every likelihood of disposal of this petition expeditiously. However, if the proceedings of the above mentioned title suits are not stayed, these civil division petition may become infructuous.
Right.
And therefore, till the pendency of the civil division petitions number 153/2024, as well as CRP number 140/2024, further proceeding of title suit number 10 of, please repeat the number.
11/2010, my lord,
11/2010, as well as
19/2011.
19/2011 are stayed. List this, when this can be listed for you.
After puja, my lord, any date, you, to the
List-
convenience of the honorable court.
Suggest court. List this matter for list these civil division petitions for hearing on 16th of October 2024. Is it okay
It is for admission hearing.
for admission hearing?
Obliged.
May it please your lordship.
Yes.
My lord, so the petitioner is arrested on the 2nd April of 24 in connection with GRPS case number 4425 under section 20B
To see.
2C. I would like to take your lordship to the FIR, where I have annexed as annexure 1 at page 9, my lord, where it is specifically mentioned, my lord, that a total weight of 11.150 kg has been found in the possession of the petitioner, my lord. Seizure list, my lord, is at 28, page 28, my lord. It's a separate seizure list. Page 28 is the type copy, my lord.
Yes.
Where it has mentioned I so and so of so and so hereby seize the below description item from the possession of Sezo Puro, 26 years. And this is a separate seizure list, my lord, where total 10 packet suspected item has been, seems to be, total weight is 11.150 kg, my lord. That is intermediate quality, my lord, quantity, my lord.
What is the date of your arrest?
2/4/25, my lord.
How many days you are behind the bar?
Today 154 days, my lord, already. So
Yes.
I have approached the session court, my lord.
What's-
Which has been rejected, my lord.
Where is the rejection order?
An extra 3, my lord,
Page number?
page 24, my lord.
You took this plea before the sessions. court.
Lordship, I have taken the plea before. At page 25, my lord, 7th. Learned counsel for the accused submitted the weight of ganja recovered from
Okay,
possession.
now
of
what is the
present, my lord.
submission?
So, my lord,
If
Since-
if there is a criminal conspiracy between
for that,
the accused, 3 accused to carry
so my
the
lord,
weight differently,
same case in a same case, my lord, there has been a, this honorable court also has passed an order
Where is that?
at page 34, my lord. Annex 6, I have annex.
In this case,
In same case, same type of case, my lord, where they were
similar,
similar, my lord, sorry. Similar case, 4 persons were traveling and the investigating officer also combined the seizure of the 4 person. Where
what this Amar
relied
Singh,
on the judgment
Amar
of
Singh
Lordship,
Ramji Bhai
Lordship.
Barot says, if there is no material to show that there is any connivance, then you will get benefit. If the prosecution can show something that there was a conspiracy to carry the, what Amar Singh Barot says,
This one, my lord,
which para?
para 8, my lord. No, para 8, no. At 6, para 6. A small portion has been mentioned here, my lord, where in the end of the para 6, my lord, in our view, however, there was no warrant for this conclusion at all, as there is no evidence.
There was no evidence to suggest that there was a abatement criminal conspiracy within the meaning of 29. Now what is
The
your
individual carrying the recovered substance. Hence, it is not possible for High Court to take the view that section 29 was attracted. That was the view by the Honorable
Okay,
Court.
okay.
my lord.
Any other submission?
That is my prayer. my lord.
Yes, what is your submission? We will hear both the cases together. Next item to the auction.
My lord, both the items arising out of the same case diary, my lord, both of them were found traveling in the same train. They were traveling together, in fact, my lord.
Yes,
Now they were traveling together, my lord. And admittedly, my lord, I was carrying, allegedly, they say I was carrying 13 kg, which is an intermediate, and the client for in item number 31, he was carrying 11 kg. Now, the only issue here, my lord, to what I understand is whether traveling together can be a circumstance to indicate conspiracy under section 29. Whether traveling together can be taken as a circumstance, traveling together to bring the rigors of 29. My lord, Amarjit Singh, my lord will kindly see. Amarjit Singh, I'll show.
Amar Singh.
Amar Singh. Now, my lord, in Amar Singh, kindly come to para number 3. In Amar Singh, what happened? 2 persons were traveling together in a small jeep. It is not a big, my lord, that they were traveling in train or in bus in some separate seat numbers are different, or they were found from different compartments, nothing of that sort. Page 3, para 3 of Amar Singh, my lord will see, both of them were traveling together in a jeep. One is Amar Singh and the other is Dana Bhai, Veera Bhai, Rabari. Now, this person died during the course of while the appeal was pending. Now, my lord, what the police did, they clubbed up both because they were traveling in a small jeep. So, therefore, it was construed that there will be a conspiracy. And, my lord, with the aid of section 29, they were convicted under both for individual possession as well as joint possession. There were 2 sentences, one for individual possession and the other for joint possession. When this matter went up to Supreme Court, at para 8, my lord will see, of Amar Singh, sorry, I'm only saying Amar Singh, para 8 of this judgment.
Yes.
I'm skip the first three line. I'll come to the observation. It is true on the right hand side, your lordship has seen. It is true. Para 8, the third line on the right hand side, it is true.
Yes.
It is true that the High Court proceeded on the footing that there was a criminal conspiracy between the appellant and the deceased Danabai such and such. In our view, however, there was no warrant for this conclusion at all, as there is no evidence to suggest that there was any such abatement and or criminal conspiracy within the meaning of section 29 of the NDPS Act. The appellant and Danabai were found together, but individually carrying the recovered substance. Hence, it was not possible for High Court to take the view that section 29 was attracted. My lord will also see that Bombay High Court judgment, if your lordship sees, this is the other one, the Bombay High Court judgment. Here also, my lord, both of them were traveling together. I'll straight away take your lordship to para 7 of their judgment. My lord, is there at para 7?
Yes.
Admittedly, police have recovered contraband of totaling 10.31 kg from the possession of the applicant and contraband totaling 11.24 kg from the possession of the co-accused. It is alleged that both the appellant and the co-accused were traveling together and the contraband recovered from their possession was commercial quantity. In my view, though appellant and co-accused found together, but they were carrying the contraband individually. The recovery of the contraband from the possession of the applicant and co-accused should be considered separately as observed by this court on such and such as observed by the court of.
So in absence of any material to show ingredient of section 29.
Now, my lord, I'll come to the ingredients of section 29. My lord, just before that, one order passed by your lordship in a criminal petition 765/23. If your lordship kindly comes to para 14. Well, I'll make it as brief as possible, my lord. Para 14. Here also, my lord, traveling together, the police, they clubbed up. In fact, in this case, there was a single seizure list, but in my case, there are two seizure lists. The material on record suggests that the present petitioner was carrying the contraband which was seized from him individually. No evidence could be collected during the investigation to link the contraband seized from him with the contraband seized from the accused Kamalesh such and such. As only 8.7 kg of suspected ganja was recovered from the present petitioner, and as apart from the fact that the present petitioner was traveling in the same bus in which another accused was traveling, there is no other material on record to show that there was any connivance or conspiracy between both the accused person named in the charge sheet. This court is of the considered opinion that there is no ground for presuming that the petitioner has committed the offence under section such. Now, my lord, for section 29, my lord, the NDPS Act, my lord, your lordship is aware, my lord, the punishment are based on the quantities. So the legislative intent is to punish a man for the quantity he deals in. Now, my lord, suppose two individuals, they go and purchase two different quantities. One may purchase 1 kilo for personal consumption. The other may purchase 21 kilo for commercial purpose. Both of them are traveling together. That is why, my lord, the law, because that will open a Pandora's box. Because me and my friend gone, I said, okay, fine, I'll just try for 1 or 2 days, I'll purchase half kilo. And one said, no, I'll go and sell it to somebody else. He purchased 21 kg. Both of us are traveling together. Will we do justice to the man who is carrying half kg? If we club up, it is more than commercial quantity. Therefore, my lord, quantity is not important for section 29. For section 29, I may carry zero quantity. But say, for example, I am a supplier. I am supplying 21 kg to her. Or I am the receiver. Or though the section does not mention these words, but in cases where section 29 is used, section 29 simply uses two terms, abate and
Criminal conspiracy.
Now, my lord, it is difficult to have direct evidence of criminal conspiracy. So therefore, my lord, the entire the question boils down to one fact: whether traveling together can be a circumstance to implicate a man with the aid of section 29. This judgment says no.
In absence of any other.
Any other. Suppose one is a supplier, one is a receiver, the other one is a transporter. The supplier and the receiver may not have even, my lord, an iota, there may be no recovery for that matter, but still they will be roped in. Because this is a direct conspiracy for commercial quantity. But here, two persons, because if they are going to sell it to someone, then that statement of the person to whom they intend to sell is required to show that
Okay,
they are
okay,
dealing.
Okay.
That's
Yes,
my case.
Mr. Sharma.
Here is, we'll kindly take up item 32, Boylan.
First one.
Yes. There, Lordship, will kindly come to the forwarding,
Just a minute.
page 15.
Page number
15,
15.
yes.
Yes,
Here, Lordship,
this is the FIR.
this is the forwarding, Lordship. I'm skipping the FIR, Lordship. It basically contains the same facts.
Yes,
Yes, I'm just reading, Lordship. The brief of the case is that on 2/4/25.
where are you reading?
Second paragraph, Lordship. The brief of the case is there.
Page number 15.
Yes, annexure 2. Forwarding, Lordship.
Please go. Yes.
Yes.
After receiving the information.
No, Lordship, it starts with the brief of the case, second paragraph, Lordship. The forwarding, Lordship. Lordship can take any forwarding of any.
Page
three items.
15,
Page 15.
para 2.
Page 15 is the FIR
Then Lordship will
No, my lord, page 15 is the forward.
in the first case.
Lordship will take up the forwarding. Forwarding will be 16.
Page 16, yes, brief of the case.
Yes, brief of the case is that on 2/4/25, complainant so-and-so lodged an FIR at this PS to the effect that on the same day at so-and-so reported through a phone call that today during a checking conducted by him along with train checking team of Guwahati GRPS on train number 12423 DM Rajdhani Express after his arrival at around 6:55 AM at platform number 1 of Guwahati railway station, they received huge contraband of suspected cannabis ganja in one trolley bag and one luggage bag from the possession of two passengers who were sitting together on seat berth number 25 and 26 of coach number A4 of the aforesaid train. So that is, Lordship, they were traveling together. Now, Lordship, down below, Lordship will find the contraband is described, Lordship, from one petitioner 13.100 kgs approximately, and the other is, Lordship, 11.150 kgs. So it comes down to total 24.25 kgs of ganja. Lordship has found it. This is in relation to the basic facts, Lordship. Now, Lordship, here, charge sheet was submitted, Lordship. Recently, on 29/5/25, the charge sheet was laid. I have, if Lordship kindly takes up the scan copy for a moment. Now the case, Lordship, is fixed at this stage of copy, Lordship. It was fixed on 13/8/25 for copy, supply of copies. And Lordship, in the charge sheet, probably if I have not checked it, I'm sorry, Lordship. In the charge sheet, in the column.
Yes.
In any case, Lordship, the contraband has been clubbed together and it has been shown as commercial quantity. That is apparent from the case reports, Lordship. The FSL report also is positive in that regard. It is cannabis. Just going to the basic facts, and Lordship will find the blue flag. This is the information that has been received from the IRCTC regarding the seat, regarding the
Tickets,
tickets.
common
Lordship will
ticket.
find same PNR number of the ticket, Lordship. Both the petitioners are shown. So it was, Lordship has found it, Lordship. It is from the same PNR number. They were traveling together. Next page, Lordship will kindly see, it was booked from Dimapur by Sizopuro, that is the probably the second. petition.
Sezopuro.
Yes, second petition, 31. Item 31. First. Lordship is found in, so that is the evidence. Now, just to substantiate it, Lordship, I am placing this judgment, Lordship, of Delhi High Court. Lordship.
So you intend to say that as they booked their journey together,
Yes. that is
purchased a
nothing.
common ticket.
Yes,
So their intention was to carry the contraband together.
yes,
They intentionally bifurcated the weight in.
yes.
Okay.
Lordship kindly comes to this judgment, Lordship. Lordship will kindly take up paragraph number 2 for a moment, Lordship. Because the issues are similar, Lordship. Paragraph number 2, Lordship is found.
Yes.
Yes. Subsequently put, the factual metric given rise to the present petition is as follows. On 7/7/24, while on routine crime prevention and detection duty in the area of Southwest Delhi, a team comprising 7 personnel from the special staff is stated to have apprehended 5 individuals, including the present petitioner, near the CGHS dispensary, Palam flyover, Palam, Delhi. It is alleged that each of the 5 apprehended persons was found in possession of ganja, concealed in backpacks. Following preliminary inquiries, the identities of the 5 apprehended persons were ascertained. Next, paragraph 4, Lords. The ganja recovered from the backpacks of the accused was weight amounting in total to 27.7 kgs. The distribution of the recovered contrabands as per the prosecution is as under. So it shows, Lordship, the first accused was carrying 7.266 kg. Second accused was carrying 6.8 kg. So it goes and goes, Lordship. Now, Lordship will kindly come to para 8. Page 3, para 8, Lordship. May I read, Lordship?
Yes.
Yes, para 8, Lordship. The learned counsel for the petitioner at the outset submitted that the quantity of ganja allegedly recovered from the petitioner is 1.990 kgs. This quantity he submitted is well below the threshold of commercial quantity as prescribed under the NDPS Act, the said threshold being 20 kgs. It is submitted that the present case involves only intermediate quantity and therefore the rigors of 37 NDPS Act, which are attracted solely in cases involving commercial quantity, would have no application in the facts of the present case. Paragraph 9, Lordship. It is further submitted that the learned special judge NDPS Dwarka courts has erred in mechanically applying the embargo under 37 of the NDPS Act to the case at hand in complete disregard of the settled legal position that the said provision is not attracted where the recovery pertains to intermediate quantity. Next paragraph, Lordship, paragraph 10. The learned counsel submitted that the learned special judge has failed to appreciate that in the absence of demonstrable evidence of criminal conspiracy, the recoveries affected from different individuals cannot be clubbed together merely to give the appearance of a commercial quantity. Paragraph 11 also, Lordship. The learned counsel submitted that the invocation of section 29 of the NDPS Act in the present matter is equally misconceived. The prosecution has not placed on record any credible material to substantiate the existence of a conspiracy or any meeting of minds between the petitioner and the co-accused persons. The statement of co-accused persons under custody cannot, in the absence of any corroborative material, form the sole basis to invoke section 29 of the NDPS Act. So that is the same submission that has been made by the petitioner's Lordship. Now, Lordship will kindly skip and come to paragraph 20 directly, Lordship. This is at page 6, paragraph 20.
Yes.
Lordship has found it, paragraph 20.
Yes.
Yes. Having heard the learned counsel for the petitioner, the learned APP for the state and peruse the record, the primary question that comes up for consideration of this court is whether the contraband recovered from the accused person, including the petitioner, can be clubbed in order to make it commercial quantity. So that is also the question that is before your Lordship. Now, Lordship, paragraph 22.
However, where section 29 on the NDPS Act is invoked and the allegation pertains to a conspiracy to commit an offense involving a commercial quantity, the statutory rigor under section 37 of the NDPS Act becomes applicable, notwithstanding the fact that the quantity individually recovered from the petitioner falls short of the commercial threshold. Then Lordship will skip and kindly come to paragraph 26. This is important, Lordship. Further, the location data retrieved from the mobile phones of the accused shows that all 5 accused were present at Station Road, Cooch Behar on so-and-so and traveled to Delhi by the same train, with their mobile phones subsequently been traced to the Mahabalipur area on 7/7/24, which is the very day and location of recovery. This synchronized movement of multiple individuals from a common point of origin to a common destination, followed the recovery of similar contraband from each, speaks to a concerted act rather than an isolated or independent instant of possession. Next, Lordship will kindly come to page 28. Paragraph 28, sorry, Lordship. In Rhythm Rana Supra, Sheila Supra, and Avadesh Yadav Supra, this court has repeatedly held that conspiracy can be inferred from circumstantial evidence, communication records, and synchronized conduct, even if recoveries are separately made. Once conspiracy under section 29 of the NDPS Act is established, prima facie individual quantities may be aggregated, invoking the embargo under 37 of the NDPS Act. Next, Lordship, paragraph 29. The Learned Counsel for the petitioner has sought to downplay the significance of the CDRs, submitting that mere telephonic contact does not establish conspiracy. While that submission may merit examination during trial, at the present stage, what is required is the existence of reasonable grounds for believing that the petitioner is not guilty of the alleged offense and that he is not likely to commit any offense while on bail. The record is, as it stands, replete with coordinated communication, collective travel, and simultaneous recovery, falls far short of satisfying the first leave of his two-pronged test. And thereafter, it dismissed the bail application. So here, Lordship, for section 29, some evidence is required. That is apparently on record, Lordship. Along with the charge sheet, it has been laid. So in that regard, Lordship, now the question of Lordship, cognizance has been taken on 37/25. Charges has not yet been framed. So at this stage, this might be entered in Lordship. That is my respectful submission.
No, your submission that evidence of 29 is the railway ticket.
Yes, PNR, yes.
Their origin of journey
Yes.
and destination is same.
Same.
And they purchased railway ticket. And what luggage was found with them?
Lordship, it was found from both their position, Lordship. The destination bag. One was a bag, one was a trolley bag. I have mentioned it in the forwarding, Lordship.
Yes.
Now, my lord,
Anything.
in fact, the judgment which he has relied on just now, my lord, there is a first thing, my lord, it was not the origin, it was the destination which was, my lord, which has bothered the court. In my case, my lord, they were intercepted from Guwahati, number one. Number two, my lord, there were some CDR reports, my lord, and there were some interception by the satellite that their movement in the same place. All this evidence doesn't, and moreover, my lord, we'll just see that.
But the
that-
ticket shows that you originated,
Then,
you
my lord,
purchased
then-
a common ticket.
then I will say, my lord, this judgment is par incuriam with Supreme Court judgment. Because the Supreme Court Amar Singh judgment, they were in a jeep. That is, the proximity is more.
No.
Yes.
No, Supreme Court says that merely traveling together may not be enough unless there is evidence of 29. Here he is showing an evidence of 29.
My lord, I might have read this wrongly. Kindly again revisit section para 3, my lord.
Para 3 of Amar
Amar
Singh.
Singh. And I'll give a copy to the learned public prosecutor also, so that next time before saying yes, he will see.
Oh.
Just I will just show, my lord, on what, because, my lord, the law takes its colors from the fact. Now in Amar Singh, the Supreme Court said that the observation made by the Supreme Court is based on which fact? This is a train, a big, my lord, so many passengers. In Amar Singh, they were in a four-wheeler jeep, only two persons. So that was a better case for this proposition by the Delhi High
No,
Court.
no, in Amar Singh, if I,
My lord, I have given a copy, paragraph 3, my lord, it is written there. Paragraph 3, it is
what
written, my
what
lord.
is written?
My lord, paragraph 3, I'll just take your lordship to 1, 2,
Only
3.
facts are there.
That is why in Amar Singh, same thing happened. They said that I am sitting beside them in the same ticket. They were in a same small car. In Amar Singh, they were in the same car.
Okay, okay.
And that was a four-wheeler car. And where only two persons were there, not even third person. So CDR and everything would definitely match. Now, so therefore, if this is the proposition which he is trying to impress on this court, then my lord, this is par incuriam with Amar Singh, because Amar Singh, this not only Amar Singh, now our High Court's view. Now, my lord, our High Court, kindly see my bail application.
No, no, Mr. Bishwas, law is very clear.
Yes,
Law is merely traveling together may not constitute an
Absolutely.
offense. But
yes,
if there is an evidence to show that there was some criminal conspiracy or abatement, then if section 29 is roped in,
yes,
then even if you carry separately,
yes.
that can be regarded as a single entity unit.
Which is why, my lord,
And
what-
his submission is that the railway ticket in this case is the evidence of conspiracy between.
that is my precise submission, my lord, that railway ticket. Now, my lord, we are traveling together on the strength of what? On the strength of, it cannot be two unknown passengers sitting together. That is not the case, my lord. In this Amar Singh, that was not the case. Both of them know each other. They were in the same car, only two persons. One was driving, one was sitting beside them. One was carrying some quantity, one was carrying some other quantity. Because that is the reason, my lord, that two friends go to a shop, not shop, my lord, go to a person and purchase two different quantities. One purchases small quantity, other purchases commercial quantity for two different purposes. One friend say, no, I will not sell all these things. Okay, I can try. Now, since they know each other, they are traveling in a small scooter, motorcycle, traveling together in whatever mode of transport, my lord, that cannot be. The
Okay.
section 29 is, because, my lord, even that Jammu and Kashmir, I should not go to Jammu and Kashmir. I mean, my lord, I should not travel so far for so
Mr.
little.
Bishwas, we have to stop.
Absolutely, I can understand, my lord, because my
I-
item was called then and then he took.
I have understood. I will consider your submission. We are reserving this.
And my lord, since your lordship is, my lord, reserving, your lordship will see that this, in the bail petition, your lordship will see, this is from our High Court, page 20. In this case, absolutely identical case. Same ticket, same
Or-
state of
or
Assam.
If you intend to argue, we can fix it tomorrow.
My lord, if certain facts.
Mine is concluded, lordship, and I am
No,
taking for a
he-
disposal, lordship.
So, my lord, he may press, he may
You-
take
you
time, he
gi-
may press.
you give
Yes, lordship, because my prayer was
in
also
writing
objected.
if you want to submit anything. Council on Naam Likhivat case. No? Let this case be listed for delivery of orders on Wednesday.
My lord, should I give a sheet of paper to the postmaster?
Yes, in a
Because-
sheet, anything you want to add to what you have submitted. Don't repeat what you have submitted. I have taken notes. Anything what,
Even I have given a piece of paper where those initials, because now
Yes.
that
if
he
you
has
want to add anything, both of you, you can submit.
because, my lord, Delhi High Court, that isolated
No,
observation.
no hearing now. On-
Meantime, I will go through Amar Singh for better judgment.
Yes.
Understanding.
Para 3 especially.
Regarding the leftover matters, you have to pray for listing to the register.
36 also.
No, but I am rising. I have a meeting.
At 2 p.m. It's been carried over for many days, lots, very urgent, lots. Small things are there. Tomorrow.
What
I
is the
should be-
matter?
CIT 4 matter, lordship. main accused has been arrested and the petitioner is the driver and police is keeping on searching him. That is why he say every apprehension that he will be Dutta at 2 p.m. also.
No, tomorrow also same will happen. Day after tomorrow,
PM lodging.
no, not at 2 p.m. It will disturb the list. Day after tomorrow and others,
My lord, my.
no entertainment. You have to pray before the registry. If there is anything urgent, registry will give dates.
I am behind the bar, my lord. I have 36 items serial number.
All are behind the bars. When your item was called for, you were not found.
No, my lord, my item, next item was my item. It wasn't, I am sitting since morning here.
Day after tomorrow,
Day after tomorrow.
Yeah.
Item number 40, I am not pressing my.
not pressing.
Not-
Dismissed on withdrawal, item number 40.
It's 40. CD also did not. come.